Your Lordship.
Same school.
Same school.
452 is next date. This next date, this is on. Yes. By order dated 9/5/2024, the instant matter was directed to be set together with WPC number 342 of 2022, which is to come up on 27/5. 27/5 next week.
Monday, Your Lordship.
Monday.
Just together. Yes.
Obliged, Your Lordship.
Take this back.
Please, Lordship. Lordship, I beg to mention item number 19, Lordship. Lordship, I'm praying for 2 weeks' time, Lordship.
This matter was heard.
No.
What's the matter about?
Lordship, this is the dismissal from service, Lordship.
Yes, sir.
Yes, sir.
These are service matters only. They can be heard. What is there?
2 weeks, Lordship.
Not ultra complicated matters.
Simple matter.
Yes.
Lordship, similar prayer for item number 28, Lordship.
20?
28, Lordship. I've informed the other council, Lordship.
No objection, Lordship.
28, what is it?
Lordship, Nehu matter, Lordship. Pertaining to those casual laborers.
No, 2 weeks. Yes.
2 weeks. Deeply obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 26. Your Lordship, let this matter come after 2 weeks. Come after 2 weeks.
Why?
Mr.
Where's the
Dev,
other side? You no objection?
Lordship, no objection, my lord. Mr. Day is on sanction leave.
Who in the city? Oh, okay.
Yes,
2
Your
weeks,
Lordship.
yes.
Lordship, similar prayer on item number 24.
You told Mr. P.T. Sama, no objection?
Because he says
He's the only one
something
with objection to adjournment. Yes.
short time may be given.
You sought time?
Yes.
24.
Yes, Your
You're
Lordship.
seeking time?
No.
What day is
I am
seeking time?
seeking time, yes, Your Lordship.
Okay, 1 week or 2 weeks?
2 weeks' time, Your Lordship.
2 weeks, yes.
Okay, highly obliged.
Yes.
Your Lordship, we beg to mention item 25, Your Lordship, on a joint prayer.
1 week or 2 weeks?
2 weeks, Your Lordship.
Yes.
Obliged, Your Lordship.
Supplementary list, item number 1.
Yes.
In this case, I represent the petitioner, Lordship.
Yes.
Cancellation of the petitioner transfer order, Lord, and withholding of salary from November 2023 till date, Lord, is the subject matter of this writ petition.
Yes.
If your Lordship takes up page 25, Lord, I was page 25.
25.
Page 25. In the year 1998, Lord, I was appointed as a handyman. And
You were appointed as handyman?
I'm sorry, Lord. No, yes, Lord. I was working as handyman, Lord. Page 25.
Yes.
Thereafter, Lord,
Yes.
I was promoted to the post of driver, page 27, Lord.
Promoted on? Can't hear from
Promoted
you.
in the year 1999, Lord. 1928/5/1999. Page 27.
Okay, yes.
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 In response to the office order, it is so and so.
Were you regularized in service?
Yes, Lord, I was regularized,
When?
Lord. It is by order, it is in the year 2009, Lord.
Okay, where's that order?
Lord. Page
Page?
38 is the order. Page
38.
38 is Lord. 38.
No, where's your regularization order?
Yes, page 38 is the order. Annexure 5, P5. May I read, Lord? Mr. Sabir Rava, works as driver.
Okay, right, okay. Royal office effect from 1st
Last
October
line.
2009. Right.
Yes. Is
Then what
regularized
happened after
from
that?
October 2009.
What happened
Thereafter,
after?
my service, after that, my service was confirmed by the order dated 2014.
Okay, right, okay. You have done?
Last name, yes. After that, there was a mutual transfer, that is, page 41. In terms of the mutual transfer, page 41.
Yes.
In terms of this trade, with Pakistan, this item that we should be mutually transferred from William Nagar to Calcutta Lodge. That was allowed by the respondent. In response to that, I joined at Calcutta Lodge from 2018 onwards.
Okay.
And I will join my salary and everything. Thereafter, the transfer order was issued page 44.
Yes.
I was transferred to Bagmara. In the interest of page 44.
Right.
In the interest of public service, Savin Rawat.
Okay, don't do that. Yes, so he transferred to post of executive engineer in the vacant post occurred. Okay, right. Then what happened?
Now, this transfer order was cancelled. I was released from Calcutta, that is page 46, to enable me to join a Bagmara.
Yes, what happened? Where's the cancellation order?
Cancellation order is at page 50.
So where are you serving now?
Now I am working at Calcutta, Milord. Though I have joined at Bagmara, but because the transfer order was cancelled, Milord, so again now serving at Bagmara.
Has someone else taken charge over in Calcutta?
No,
No.
No. Now, the difficulty, Milord, is that after this order of transfer was cancelled, the executive engineer wrote one letter, Milord, to the superintendent engineer, which is page 52. In terms of this letter, Milord, the post of driver at Calcutta is not a sanctioned post. And because of this, they are not releasing my salary. This is the core subject matter of this expedition. Now, I am a regular employee. Can you transfer me to a non-sanctioned post, thereafter withdraw my salary? Stop my salary.
Yes, Ms. Karuna, you take instructions.
Oh, child.
Heard Mr. E. Lal.
Let me have paid for some interim relief. For 6 months, I am not getting my salary.
Let them come instructions first after 2 weeks. Yes, heard Mr. E. Lal issue notice. Mr. H. Kharwan Lang.
Watch for.
Yes, so we have all the respondents. So no further notice called for. This one for 2 weeks for instruction after get.
Can it be on June 14, Milord?
Yes.
14th of June, Milord.
Yes. What are you saying?
14th of June. Can it be on 14th of June, Milord?
2 weeks, yes.
Can it date be convenient
Daily
for
list?
us?
Local counsel is here. Fine.
Daily
It's not
list
a-
item
it's
number
a
1.
complicated matter that needs a counsel outside to argue. Yes.
Oblige.
Oblige.
Yes. Yes, Mr. Nagar.
This is the gratuity matter, my lord, which
However, I have filed an application for placing the matter before the division bench as the virus of gratuity rule is being challenged here. And under the High Court rules, Rule 4, it should be placed before the
You've received
division.
copy of the business application, Mr. Nagar.
I've received.
You object to this?
There's nothing that I can say, my lord, because
But
there are
the
no
thing is that
grounds.
it's already a
And even the challenge to the rules, my lord, that was there in the previous my lord, matter also, my lord.
beating a
Let
dead
it be
horse.
placed before the DB, let it be considered by the DB.
This was application, Miss case number 82/2024, Lucy 104/2024. This is an application by the Petition Association for placing the instant matter before the division bench in view of the fact that as submitted by the Leonard Senior Counsel, the virus of the Shillong Municipal Board gratuity rules 980 have been put to challenge. Mr. Prem Nongbri, everyone has no objection. Miss case allowed. A registry directed to place the records of the instant matter before the division bench. Yes.
Thank you.
Item number 2.
Your Lordship, I pray for 3 weeks' time to file rejoinder.
You have not been well.
Now I have a little bit improved, but I'm still very weak.
Okay. No objection.
No objection, Lordship.
DK Datta, Council Petitioner, paper, and is allowed for the 3 weeks time to file rejoinder.
Obliged.
Item number 3.
My Lord, affidavit has been filed, my Lord, on behalf of the state respondents.
1, 2, 6, 8, and 9.
My Lord.
7, file.
7 is yet to be filed.
You're not filing.
We'll be filing, Your Lordship, but taking so much time from Your Lordship.
I can't hear you.
We need this further time.
We're paying for further time, Your Lordship.
How much time?
2 weeks time, Your Lordship.
MS ARC only submits that the affidavit on behalf of R1 to 6, 8, and 9 has since been filed. The MS Net Pasa Council prays for further 1 week's time to file affidavit. Prays allowed this thereafter.
Item number 4.
Lordship, rejoinder is not yet filed.
My Lord,
You want to file rejoinder?
during the course of the day, we will file it,
Very good. Council Petitioner submits that the rejoinder after will be filed in the course of the day. This matter for hearing after 2 weeks.
Much obliged, Lordship. 5.
Please, Lordship. Asha, I pray for some more time, Lordship. It's almost ready. Just need 2 weeks' time, Lordship.
How's the what stage? First paragraph done.
Lordship, drafting is almost ready. Just legal points, Lordship. Substantial.
Lordship, even we are praying for...
You have already filed yours?
No, Lordship.
No objection?
No objection, Your Lordship.
Very good. Yes, you're calling for R1 to 5 and Mr. 5 pray for not for the 2 weeks time to file affidavit. Just thereafter and so on, sir.
Item number 6.
Yes. Settle.
Lordship, in this...
Your Lordship, on that day, due to absence of the private respondent, it could not be
Who's the
settled.
private respondent? Who's the appearing private respondent? Who's the council private respondent? Your council private respondent? Number?
6 to 10 and 13 to 15.
Cannot hear.
6 to 10 and 13 to 15, Lordship.
Okay. What to do this? Yes.
Lordship, as per, I had made submissions on the previous day, Lordship, that a representation has been made to the government. So, petitioner had taken time last time to seek instructions whether matter can be disposed of with the direction from this court, honorable court, that the representation may be disposed of within 4 weeks, Lordship.
You agree to that?
Your Lordship, this matter may be kept pending. In the meantime, let them dispose of our representation. Your
Why?
Lordship.
Last time, oh yes, you only were there. That was on 24/4. If they dispose it of, it'll give rise to new cause of action. Then you might have to withdraw the petition and file afresh. What instructions have you got?
I don't have any instruction.
You
Your
never
Lordship.
sought instructions.
Today, I don't have instruction, Your Lordship.
We left out 1 week to enable MS Asylum to obtain instructions. Pursuant to order dated, last order was when was that? When they allowed to take instructions?
Lordship, 7 May, Lordship.
No, that was pursuant to order dated. (24/4/2024). Yes.
Item 7.
I oblige.
Yes.
On the last stage, Your Lordship, Marwari Panchayat was allowed to be impleaded. So the impleaded party has to file an affidavit.
You file affidavit, you already filed. You received copy?
Yes, Lordship, they have.
On number 4, newly impleaded. Yes, MS Bijarwa submits that the affidavit we have to fully find the course of the day. You have already filed yours.
We have filed an affidavit.
Lordship, I pray for 3 weeks' time to file rejoinder.
Rejoinder.
This is the matter after, also for rejoinder by the petitioner.
Item number 8.
Affidavit filed?
Lordship, we have already filed affidavit.
Very good. Yes.
We pray 3 weeks' time to file rejoinder.
You're Mr.
H. Yadav, my lord. H. Yadav.
Yes, H. Yadav, on behalf of the petitioner. Praise is allowed 2 weeks time for rejoinder. Was from far out, okay, 3 weeks time. That's what rejoinder, this thereafter.
Highly obliged.
Highly obliged.
Item number 9.
Maybe Lordship, in this matter, the government has filed the affidavit. I have filed the rejoinder, but one judge additional that they have not filed the affidavit. Another, this not AG. Is
it necessary?
Let them file the applications they also wanted to file it.
Yes, MS USA submits that as will be House Number 6 will file the course of the day. You don't file rejoinder?
I have filed. Maybe if required, then they will say I'll go to. I'll go to
matter
the
after 2 weeks. Yes.
Lordship.
For the orders.
Lordship.
Petitioner may file a rejoinder.
Yes.
Meanwhile, if so advised. Yes.
Item number 10.
First place, Lordship.
We have, my lord, we have filed the affidavit to, they have entered appearance.
Yes. I'm entering appearance on behalf of Respondent
Yes.
number 2, 3, and 4, Your Lordship.
Who appears?
AG Meghalaya.
What about number 1?
This, in this case, my lord, affidavits may not be required, my lord, because simple directions. Here, I am the legal heir of my late mother, and earlier my sister was drawing the family pension. But after she attained the age of 25 years, she was not entitled to. So now since I am spinster, not yet acquired 25 years of age, and also, my lord, my name is there in the records, in the book of my mother. I had applied for the pension. They are not denying. The only problem that they are asking me to run from pillar to post is that they're saying that my name is not there in the EPPO. EPPO.
What is that?
EPPO means it's an online where they can see the legal heir's name and all. That is not there. That is only problem. So now it's not my problem that I can go solve to a EPPO. Only they are to act, that is. Only that much, my lord. And this was due for quite some time.
You're not filing affidavit?
Lordship, we're filing, Your Lordship. Small
The course of the
affidavit.
day?
No, Your Lordship.
Why is it such a... there's no problem. Why not giving the pension to the...
Your Lordship,
to the petitioner?
if you'll come to page 22.
Of the petition?
Yes, Your Lordship.
What is the problem?
Your Lordship, the name of the petitioner, since the PPO has converted to her sister's name, her name was not reflected in the
Sister's name
PPO.
is Milvan.
Yes, Your Lordship.
Okay, then.
Your Lordship, I'll seek instruction, Your Lordship. I'll seek further instruction.
Where's that objection they've raised where you said that it's not an EPPO? Where is that with petition?
That is their communications, my lord. I'll just show that communications.
Which page?
Just give me. Now, before that, my lord, I'll just take my lord to page 20 first, my lord. Before that, I'll just answer to that one also, my lord. Page 20. This is the details of the family.
Okay. Date of birth 2000.
Yes, my lord. Yes.
Okay,
Yes.
now-
So Magdalene Lingdo it's me, my lord, and it is there in my mother's record. And now, just give me a second, my lord. This page, the PPO. Where is that page? Just show me the page. No?
What do you want to show?
The PPO, my lord, where they say that there's no PPO. This is the one signature.
Where is it?
With references.
If that's the main objection, you should have it. Where is it?
My lord, here, this page 64, my lord. Page 64. Annexure 12, my lord. So this comes from the branch manager. My lord has a page.
Okay.
So
okay. Take down the writ petitioner. The writ petitioner's grievance is that when did your mother die?
My lord, my mother died in the year 2012, September 2003, my lord.
The petitioner's grievance is the non-release of family pension in her name after her elder sister, on attaining the age of 25 years, has since become ineligible for the same. Stop. Mr. P. Ubin submits that the name of the petitioner has already been supplied since the year 2003, as is evidenced by what next year is this?
That's the that's page.
It's on the what?
My lord, that's a page. Page 20, my lord. Page.
Of course. What is this? As follow. As a family member by her late mother, who expired on
12th September 2003,
wherein the date of birth of the petitioner has also been shown to be 30/5/2000. He submits that the only impediment is the name of the name is the non-appearance of the name or petitioner in the. Is it a portal or is it in the system?
It is a portal, my lord. EPPO portal.
Yes, in the EPPO portal. So we therefore praise that next one, MSEB Pasal Council for the respondents number
2, 3 and 4.
2, 3 and 4. Praise without to appeal instructions. It is noted that the reason for non-payment seems to be very trivial. Accordingly, it is expected that without the need of affidavit, endeavour shall be to dispose of the matter on the next date.
My lord.
On a field of instructions is.
Highly obliged.
Item 11.
Your Lordship, I'm praying for 1 week's time to file our affidavit, which is waiting for the deponent, Your Lordship.
You took steps?
Yes, Your Lordship.
5 to 37? All of them?
Taken steps for all the private respondents.
The MS said in a hurry praise that she will allow further 1 week's
1
time
week's time
to file affidavit. Stop. It is also noted that steps have been taken on the respondents 5 to 37, whatever service reports still awaited. Accordingly, this is matter after 2 weeks.
Advised, Your Lordship.
Item number 12.
May I please, Your Lordship? Your Lordship, I require 2 more weeks, Your Lordship, to file the affidavit.
Why? You're 2 and 3.
Yes, Your
What's the
Lordship.
matter about pension?
This
That
regard to
BPC
settlement of retail outlet.
That BPC.
Settlement of retail outlet. BPCL. Mismatch in PAN card.
That matter, yes.
Yes, Your Lordship, there was a spelling mistake in the PAN card.
Yes, okay. You're for 2 and 3?
Your Lordship, I am for the respondent one, but we are not having any rule because no relief is.
You are 2 and 3?
Yes, Your Lordship.
Who's Mr. Kharmujai?
He's my colleague, Your Lordship.
Your colleague, okay. Then Ms. Bijarwa's praise is allowed further 2 weeks' time to file affidavit on behalf of the response 2 and 3. Less thereafter, interim order pass. Earlier shall continue the next date.
Much obliged, Your Lordship.
Mr. Debnath, on behalf of 101, submits that no affidavit will be forthcoming from the said respondent as they only a formal party.
Much obliged, Lordship.
Item 13.
Your Lordship, in this case, the petitioner need to implead necessary party because what this office of this divisional forest officer West Garo Hills Social Forestry Division is a necessary party, but the petitioner has not been impleaded as necessary party. As if I'm pleased,
DFO of
this.
What's the matter about Mr. Sangma?
This is regarding pension because my father was working.
He was working in the office of DFO?
Yes, Lordship.
And he didn't make him a party?
We have made a divisional forest officer, Social Forestry Division, West Kasi Hills, North State Meghalaya. Because at the time when he was retired, that the disease was the last posting was on the divisional forest officer,
then
Social
why?
Forestry.
Your Lordship, I'm pleased to take the page 18 of the writ petition. Page 18 of the writ petition. The petitioner mother has already been transferred since in the year 2012 to this. That is page 18.
Of what? Of the writ petition?
Yes, of the writ petition. Page 18 of the writ petition.
In court's copy, there's only 17 pages.
17?
Oh. Has been transferred to the office of West Garo Hills Social Forestry Division in the year 2012.
Just I. Just where's the page 18?
I got
See the court's copy.
Copy is page.
Where is showing your copy to? Where's page 18 in the court's copy?
There is only till 17.
Till 17.
Where's 18?
In my even in my page also.
Sorry,
it is 17.
I think they have given the additional
document from somewhere and put in your petition.
This is not a petition. This is not my petition, though. This is somebody's. It's not my petition. This is my petition content only till even here in my copy.
What's the name of the petitioner there?
Whatever maybe, but it
No. What is the brief number in your petition?
It's the 30th April. I think that the department has.
No, give the number of the petition.
Read number is WPC 113 of 2024.
How is it possible that you have a different one and the court here is a different one?
No, I also have same copy. I don't have.
Where does page 18 come
even
from?
That page 18 I did not enclose, my lord. I have not seen this because this one is the new fact. I have no knowledge with regards to.
But I think this must be furnished by the department. I apologize, my lordship. My apology.
That
but what happened is that this year the petition has been transferred to the office of this.
You can't have this kind of, you're supposed to be officers of the court and advocates who are handling the records of your clients in a certain way that,
they've given some additional pages
before the court to assist the court. If the job is to confuse the court first at the outset, and I don't understand really.
But
no, he has brought some document from the office.
From the office.
Whatever it is,
yes,
but he referred to page 18, it doesn't exist.
Yes, lordship.
That's my apology. I think this is from the office there because the office has written back the writ petition stating that the petitioner's mother has already been transferred to.
That submissions.
He retired. The petitioner retired not in this West Kasil but in the West Garo Hills or social welfare.
See, we don't know about that. So, where's the document here? You tell them that first. You file your affidavit. Then I don't know what orders to pass also.
Let him file the affidavit, my lord, because
yes.
I'll do that, your lordship.
Certainly.
14.
Was pleasure.
This further 2 weeks time allowed for affidavit. There seems to be some confusion with regard to the pleadings or with regard to the contents of the petition. Counsels to ensure that such incidents do not occur in future while placing materials before the court.
14.
Absurd, Mr. Shulai. I mean, this is the level of what is it, I'm very sorry to say what you have done advocates now. Very. Yes, there's a few of them who perform very well. The rest, a lot to be said. Before, in the same amount of filing, this amount of filing is the same. In the panel, there will be 4 advocates, and it handled the entire brief of the government. There'll be a senior advocate, there'll be additional advocate general, and that's it. You handling briefs that way, I mean, it's yes.
Lordship, so far this matter is concerned, Your Lordship, we have the instruction, Your Lordship, file the affidavit.
You file affidavit.
Lordship, we will file it.
What instructions have you received?
Lordship,
with regard to that,
it appears, Your Lordship, there is a disputed question of facts, Your Lordship, because they have denied the department also, Your Lordship.
Okay, Mr. Andishwarai submits that instruction been received. If we are not allowed to,
let it be 3 weeks.
Within 2 weeks, yes.
Let it be 3 weeks, Your Lordship.
Why 3 weeks?
Lordship, because certain copies are not readable, Your Lordship, will have to.
Okay, 3 weeks.
Apply, Your Lordship.
6 and 7 were dealing with trade. 6 is the Ministry of Road Transport and 7 is National Highways Authority. So I represent only 6 National Highways with their own standing council.
Who's National Standing Council for NHITCL? Who is the Standing Council for NHITCL?
Last occasion, Lordship, A. Pradhan has appeared for 6 and 7.
No, that's what the senior said, no. So like, I thought 2 weeks I'm granted. There's brought note of the court, that is Respondent number 7, who was newly impleaded, that is the National Highway Authority, is not represented by the learned DSGI. Petitioner to serve copy on the Standing Council for this said Respondent. Yes.
Apply, Your Lord.
15.
May I please, my Lord?
Yes.
On the last date, my Lord was pleased to fix today for arguments on the interim prayers.
Yes.
This matter, Your Lordship, I'm appearing on behalf of the respondents, Your Lordship. This matter is regarding the relaxation of the upper age limit for the petitioners, Your Lordship. Now, Your Lordship, the writ petitioners are relying on the office memorandum dated 3/2/2022, Your Lordship.
Page?
At page 18, Your Lordship.
Page 18.
Annexure 1. Office memorandum. Increase in upper age limit for entry into government service. The Governor of Meghalaya is pleased to order that the upper age limit for entry into government service.
Oh, okay.
Into government service is hereby enhanced from 27 to 32 years. That is, he/she must not have exceeded age of 32 on the first day of the year of advertisement. Candidates belonging to the scheduled tribes and scheduled castes will continue to enjoy a further relaxation of 5 years over the upper age limit of 32 years. They're relying on this part of the OM, Your Lordship. But in the second paragraph, Your Lordship, may kindly see the new upper age limits will be applicable in case of all categories of posts except for certain categories of posts as may be notified by the Personnel and ARA Department for the Home Police, Excise, Registration, Taxation and Stamps, Home Guards and Civil Defense, Prisons and Forests and Environment Departments.
Yes. Yes.
Now, Your Lordship, we are relying on this new, except for certain categories of posts, Your Lordship.
The exception.
Yes, the exception. We are. Now, Your Lordship, by an advertisement of 6/3/2024.
Where is that?
58 minutes. At page 58. Where's my chashman?
Yes.
By an advertisement dated the posts for the constable has been
This is
fixed.
6 March.
6th March, Your Lordship.
Yes.
At page 61, Your Lordship.
Let's see, afternoon, As per the revised uniform guidelines.
For the post of constable, it has been fixed.
Where is
The
that?
lower age limit has been fixed from 18 to
Where is that?
21. Here's 62, Your Lordship. The lower age limit is 18.
Unarmed branch constable.
Yes,
okay.
unarmed branch constable, fireman, driver, fireman, MPRO operator, all these, Your Lordship. The lower age limit is 18 and the upper age limit is 21 years. And with a relaxation of 5 years to the scheduled caste and scheduled tribe.
Be 26.
Yes, that will be 26, Your Lordship. And for the SIs, Your Lordship, the lower age limit is 18, Your Lordship, at page 61, and the upper age limit is 27 years, with a relaxation of 5 years for SC/ST candidates, Your Lordship.
Constables, yes.
For constable, it's 18 to 21, and for SIs, it's 21 to 27 years, with relaxation of 5 years for SC/ST candidates.
Okay.
Now, Your Lordship, this age has been fixed by as per the provisions of the Meghalaya Police Act 2010, Your Lordship.
You haven't filed affidavit?
I have not filed because we got the instructions in last evening, Your Lordship.
Okay,
So we were not in a position to file.
When is the recruitment closing?
The last date is 31st of May, Your Lordship, of receiving applications. So, Your Lordship, the Meghalaya Police...
it would be good if you could put your objections on
in writing, Your
affidavit,
Lordship.
But you have to file it within...
within the 31st.
Next week is 24th. No.
Tomorrow is 24th.
Tomorrow 24th. We don't have time then.
No, we don't.
But can you put an affidavit by tomorrow?
By 28th, Your Lordship, if...
But it'll be too late.
Your Lordship, I may be allowed to just show
if
these...
you file affidavit, if they have no objection to that, fine.
Then the Meghalaya Police Act, Your Lordship...
Now, where are we? Yes.
No, these age limits have been fixed as provided in the Meghalaya Police Act, Your
This is
Lordship.
the act.
Yes, Your Lordship. I have given the act also, Your Lordship, over there. In section 23, 1, Your Lordship, recruitment to the post of constable. Page 86 of the Act, Your Lordship. The age group for recruitment as constable shall be 18 to 21 years with relaxation of 5 years in case of SC/ST candidates.
Okay,
The minimum education qualification will be 10 plus 2. This is for the constable, and this is as per the Act, Your Lordship. And section 29, Your Lordship, is recruitment to the post of SIs.
Yes.
The age limit is
Yes.
20 to 27 with relaxation of 5 years for SC/ST candidates.
Right, okay. 23-1.
23-1 and 29-1, Your Lordship.
29-1, okay.
So, Lordship,
Yes.
then the exception, Your Lordship, has also been, even the Department of Personal ARA Department has on 1st May 2024 notified that these categories of posts, services, will not come within the purview of that office memorandum dated 3/2/2022, Your Lordship, on which the petitioners are relying, Lordship. Home Police Department, in pursuance to the office memorandum dated 3/2/22, the Governor of Meghalaya is pleased to order the minimum and maximum age limit for entry into different categories of posts in excise registration, taxation and stamps, forest and environment, home police and civil
Do you have
defense.
a copy of this?
No, I'll serve them.
That's
over.
what I'm saying. The thing is that you write,
I
you
can-
make a short, at least give them a chance to reply.
Rebut.
That is all.
Can we do it on Monday, Your Lordship, if the other side?
Then, my lord, you have to extend the time for...
No, we'll file it by tomorrow, Your Lordship. It may come up on here for
Monday
hearing
you
on
can file, yes.
28th.
Take down, today has been fixed for hearing on the interim prayer of the petitioner. Next param, MST Yangi, learned AAG with so-and-so, has produced certain documents, especially the Meghalaya Police Act 2010, as also an office memorandum dated
1st May, Your
of May
Lordship.
2024, which carves out an exception to the memorandum dated
3/2/22
with regard to the prescription of the qualifying of the eligible age. She's directed to put the same on affidavit. You don't need to make any submission
Lengthy one.
on affidavit and file the same by tomorrow. This is a matter on Tuesday.
Tuesday.
On Tuesday, yes.
Okay.
On Tuesday for admission hearing. Yes.
Glad you much.
Highly obliged.
You file your objections by Monday. Yes. Do you have
Okay.
any?
Hearing.
I will dispose of yes.
Hearing supplementary list item number 2.
My Lord, this matter, my Lord, I pray for Monday, my Lord.
No,
I'm
it's
also
not
interested
for disposal. They have a certain problem because the pendency of this matter. That's why when request for adjournment was made yesterday, there was an objection that because of the pendency of the matter, what happened?
It's a
You
deep,
can't,
deep borewell, my lord.
they can't dig any
They could
wells.
not, the contractor could not complete it. Now we have to retender and because of facing water scarcity, my lord.
My Lord, there is no stay order also, and they are also not allowing me.
There's no stay order, so that's what. But then they
are also not allowing me to withdraw all my materials are lying there. I'm also really committed for early disposal. It really affects my business also.
It's almost
So
one
I'm
year.
worried
material is
for-
still there.
All the
They
materials
don't
are
allow
there.
him to work anymore.
They don't allow
But he
him
has
to come
totally
and work.
spoiled that. Whatever boring he did, my lord. Because after doing the boring, the pipes have to be inserted immediately. Otherwise, there's a landslide kind of thing inside, my lord. He delayed it for almost a month. Then he brought the pipes, and the pipes are not going inside now, my lord.
What the waters are there in the
No,
additional
forget about the nature work. What's the situation of the case? Why do you say that you cannot allow to work to someone else now?
My lord, because of the pendency of the matter,
There are
as
no
a
stay orders.
extra caution, my lord. If your lordship grants us that liberty, my lord, only that much, my lord, that we are free to go ahead with the work, my lord.
Have you measured the amount of work he's done?
They didn't do this.
But we are not doing there, my lord. That will remain as it is. Because you have
That is
to,
why-
you have to
that
do
is
it
the
at some
problem.
other place, my lord.
In the contract, they have to determine the contract. And what I
But
entitled,
they are
they have to
doing
pay
the-
back.
My lord, we have filed
You're not going to
affidavit.
dig the same place.
Same place is not possible, my lord. We have to explore some other area, my lord, and then go ahead with the border.
place he
You
has
say
take.
This prisoner spoiled the entire
He has spoiled
source.
totally, my lord.
Water is coming out.
It's coming.
Yes, it is there.
They're using it.
Unofficially, the Jawans of the PSF, they come and use
How
it.
can they do it, my lord?
I
Borewell,
pray for,
the
I pray
pipe
for
has not
Monday
gone
on
inside, my lord.
because he has given a letter to the authority also to allow him to withdraw those materials.
They
I
will
just
have
take
it
the
here on
instruction
Monday.
and Monday.
Those issues, my lord, at least kindly grant us liberty to only that much one line observation also. my lord.
Monday, my lord. Monday. Otherwise, tomorrow, my lord. We'll go for final hearing if Lordship permits me. The
No,
issue is only-
what is his problem, my lord? If he is entitled to any amount of money, my lord, out of that contract, he'll be paid that, my lord. But he cannot, on that pretext, my lord.
That is true.
My lord, kindly see.
No, but the thing is that
You filed
what was the time
affidavits
of
in September, my
completion?
lord.
You are allowed to complete the contract how many days?
Within 2 months.
You never
And
did it.
unable to complete because there was a delay survey on their part. An extension was given till May, and he completed. And there was a dispute among themselves, and the water is still
You measure the
available.
work, you pay over whatever work
Well,
is
we'll
done.
do that.
The
We'll
thing
do
is
that.
that if you have a dispute, let him go to civil court for damages.
Well, we'll do that, my lord. But
What can we do in court now?
Only, my lord, here we are challenging the blacklisting order. Now, the issue show cause notice
When you
for
do the
termination.
you do the kind of work, naturally you should be blacklisted.
Here, the terms of contract says that
Blacklisting for how many years? 2 years?
he has forfeited me 3 years.
3 years blacklisting.
Yes, and he has distributed
When was the blacklisting order passed?
from June 2023, and he has circulated all the central institutions, the intent of the officer. If they depart me from BSF, I have no grievance.
See,
but circulated all the
It's only
institutions.
debarment, my lord, not even blacklisting, my lord.
It's
Lordship,
not
kindly see
blacklisting.
page 109, my lord.
It's a blacklisting.
Of the
So I
it's a
pray for my
debarment
lord.
only, my lord.
If not, my friend has a reservation on Monday. Come on, tomorrow, my lord, for final hearing.
My lord,
Only
why
issue is, my lord,
why
blacklisting
he
order
wants
is
to block, my
valid
lord?
or not.
In any case, he is not going to get this contract for the second time, my lord.
They may not
Okay,
give me.
take down,
They may not give me.
like this. In the instant matter which concerns
Installation of deep tube well.
Installation of deep tube well in the premises of the respondent
At Umpling.
BSF at where is this?
Umpling.
At Umpling, Shillong. Wherein the writ petitioner, on being debarred, has approached this court. There are no orders operating whereby there is any restraint on the respondents to retender the said work. Stop. However, Dr. N. Muzika has submitted that due to the pendency of this instigated petition, the respondent authorities have not gone ahead to what?
To retender the matter.
To retender the said work of drilling the deep tube well. Stop. Mr. H. Sangreso, that's senior counsel appearing for a petitioner, also concurs his submission to the submission and submits that there are no interim orders and that the only grievance that the petitioner has is against his debarment.
His blacklisting order.
Which contains amounts of blacklisting. Which contains amounts of blacklisting. So, in his view, the matter, no orders are necessary at this stage, then inasmuch as there are no stay orders restraining the respondents from retendering the work. Just a matter on?
Next
after 2 weeks for hearing, yes.
Yes, hearing.
Take your time. But you measure the work and finish it off.
Yes,
right?
yes.
Daily list, item 16.
Yes.
But here you are required to file an affidavit, my lord.
Short reply.
Short reply. Well, here
why not filing it?
Well, here what happened, my lord, it appears that there are some discrepancy in the affidavit, my lord. So, Lordship either permit me to amend the affidavit or to withdraw and file a fresh one. There's
you some discrepancy in the advertisement?
In the affidavit, in the date, my lord, when the post was sanctioned. There is
Your Lordship, I would like to point out in their additional affidavit,
in the additional affidavit?
Yes, Your Lordship. They have written a wrong statement on oath, Your Lordship. They have written in para 6, Your Lordship. That
let's see that. Wait 1 second.
Yes, Your Lordship. Additional affidavit, Your Lordship.
Additional affidavit?
Yes, Your Lordship. Of respondent number 1.
That is filed on 28/9.
11 September 2023, Your Lordship.
Okay.
Para 6, Your Lordship.
Yes.
The last line, Your Lordship. In the year 2019, as such, 5 posts of magistrate first class were lying vacant, Your Lordship. Your Lordship, if you may kindly come to my affidavit bringing on record the strength of judicial officers, which I filed on 22nd April 2024, Your Lordship.
Yes, yes.
Page 7, Your Lordship.
Yes.
Your Lordship, if you kindly look, Your Lordship, in 2019, the magistrate sanction strength was 4, Your Lordship. And it's this, the statement is given by the respondent number 1 to me. It's the official.
5 posts, he said.
Your Lordship, 4, Your
Lordship. The only discrepancy that 19 should be 21, my lord. Where we have written 2019, my lord, it should be 2021. That's the only mistake, my lord.
Your Lordship, this mistake is not just in para 6, it's in para 7 also and also in para 8 also. So this is not a mistake, Your Lordship.
So when the application was floated in 2019?
Yes, Your Lordship. And that time it was floated only 3, Your Lordship. However,
that 2019 is
Your Lordship, in their counter affidavit which was filed in 2020.
So, Dr. Mozika doesn't make sense because the thing is that now you're saying the year 2019, 5 posts were lying vacant. And because 5 posts lying vacant, you decide to fill the 3 out of 5 vacant posts. So that's why
In fact, it is 2021.
this is
because 2 posts were, in fact, 3 posts were anticipated at that point of time, my lord. So 2 posts were sanctioned in 21 and 1 post was sanctioned in 22.
See, now no one can prevent filing additional affidavit to try to correct it, but the courts consider it. You cannot.
It was a simple mistake of a year.
Your Lordship, they have.
Who drafted this affidavit?
Your Lordship,
it was drafted from my office on the basis of instruction given by them.
Your Lordship, they have found this mistake after a period of 7-8 months. That also after I filed this affidavit, Your Lordship. It is not their genuine mistake, I believe. Now they want to correct their mistake, Your Lordship. So this may not be permitted. It's my humble submission, Your Lordship. And Your Lordship, the respondent number 1 is trying to...
So see, the thing is that if we do not allow, nothing that we disregard it, now the statement's in the air because we have to go by what is the statement showing the strength as per the, this is the RTI report.
It's not the RTI, but it's the...
Is the?
We wrote a letter to respondent number 1.
Right.
Yes, Your Lordship. So they have
same
given
person who swore affidavit, same person has given this.
No matter. This is Deputy Secretary.
This is given by the
Joint Secretary.
Joint Secretary.
This is given
Now,
the
who swore
petition.
affidavit in this your affidavit?
Secretary, madam.
So Secretary doesn't know and Joint Secretary knows. Well, you see, it's not that. It's not a question of all the respondents trying to cover something. It's just that from the Joint Secretary you've got correct information, right?
Your Lordship, but in my humble submission, it's the whole district council should be knowing it, Your Lordship. It's not just one person doesn't know. It's the same department, Your Lordship.
Correct information, correct?
Sorry, Your Lordship.
They provided the correct information.
Yes, Your Lordship.
But in affidavit they've written wrong information.
It's wrong.
So, otherwise, hearing can proceed on the basis of by assuming that the post was sanctioned in 21. Well.
Yes, then we will disregard that. We'll hold it. We'll take this to account only.
Yes, Your Lordship. But Your Lordship, the respondent number is trying to mislead Your Lordship. Here, our main core, Your Lordship, is in the year 2019, only 3 sanctioned posts was there, which was duly filled, Your Lordship. However, the respondent 4 to 6 was given
they've made
without any advertisement, Your Lordship.
My lord, they appeared in the exam, they could not qualify, my lord. And now they're...
That we will address. The thing is that also there's no anticipated vacancies and whether they're clear vacancies. That's what we'll have to address. You start the argument. Yes.
Okay.
How long will you take? 10 minutes.
Within 5 minutes.
5 minutes.
I'll try to finish, Your Lordship.
No, take your time, doesn't it? All parties are represented. Yes.
Your Lordship, in the year 2019, advertisements was floated, Your Lordship.
Yes.
That is page number page 31 of my writ petition, Your Lordship.
Page
31, Your Lordship, Annexure 1 of my writ petition.
Yes.
Your Lordship, the advertisement dated is 6th November 2019. For the post of Magistrate First Class Subordinate District Council Court, Khasi Hills Autonomous District Council, for 3 vacant posts, Your Lordship. Thereafter, applications were given, and out of that, 6 candidates were called for interview, Your Lordship. Thereafter, out of the 6 candidates, the first 3 candidates were successful, Your Lordship, and their approval and their appointment / come waiting list is in Annexure 4, page 34, Your Lordship.
Yes.
34, dated 11 January 2021. The first 3 candidates
now
secured, Your
you
Lordship.
mean to say that the advertisement was 19?
Yes, Your Lordship.
Then exams were held on?
Exams were held on 8 December 2007, sorry, Your Lordship, 7/11/2020, Your Lordship.
Advertisement 6/11, then 11/1, 21 is the list, merit list.
Exam were held on 7 November 2020, Your Lordship. And their list came out on 11 January 2021, Your Lordship. The first 3 candidates secured the highest marks, and thereafter they were given appointment, Your Lordship. The respondent 4 to 6 were kept in the waiting list, Your Lordship. Your Lordship, the result of the last line, Your Lordship, the result is valid for a period of 1 year from the date of this notification, implying that the waiting list is also valid till 1 year, Your Lordship. Thereafter, Your Lordship, on 19 August 2021, Your Lordship, Annexure 5, page 35, Your Lordship.
Yes.
The respondent number 3 wrote, Your Lordship, respondent number 1 wrote a letter to respondent number 3 saying that there are vacant posts, and as such, it is not conducive to conduct fresh examination, and special consideration may be given to respondent 4 to 6, Your Lordship. They seek, respondent number 1 sought for respondent number 3 permission, Your Lordship.
Okay.
Thereafter, Your Lordship.
Because of COVID?
Yes, Your Lordship. Because of COVID and all the reasons, Your Lordship.
19 August.
19 August 2021.
Okay.
Then, Your Lordship, on 25th October 2021, the respondent number 3 approved their appointment, Your Lordship. Here, Your Lordship, I would like to say that the respondent number 1 did not initiate any new fresh advertisement, directly sought for approval, Your Lordship. And even the respondent number 3 did not verify whether any fresh advertisement was issued.
R3 is registered judicial service.
Yes, Your Lordship. Approve the appointment of respondent 4 to 6, Your Lordship.
Yes.
Your Lordship, on 6 December 2021, Your Lordship, Annexure 7.
Yes.
The waiting list was extended, Your Lordship, till 31st March 2022. Initially, it was till 11 January 2022, but they have extended till 31st March 2022, Your Lordship.
Okay. That is an
However, the extension of the waiting list will not have any effect, Your Lordship, because the first 3 candidates were already joined the post and is continuing till date. None of them have retired, demitted the office, and none of them has demised, Your Lordship. Thereafter, Your Lordship, on 6 December itself, 6 December 2021, Annexure 8, Your Lordship, the respondent 1 forwarded the approval given by the respondent number 3 to respondent number 2, that is the Joint Secretary to the Government of Meghalaya. Thereafter, the Governor has also approved, Your Lordship, in the next annexure, Annexure 9, page 39, Your Lordship, dated 4th February 2022. Respondent 2 has also approved. Thereafter, respondent 4 to 6 have duly joined their post, Your Lordship. On different dates, Your Lordship. One have joined on 3rd. This one. On 3rd of March 2022, one has joined on
28 February.
Yes, Your Lordship. On 8 March. Sorry, Your Lordship.
One is 28. Yes, okay. Yes.
Third. Annexure 43, page 43, 44, and 45 is their respective joining reports, Your Honor, Your Lordship.
Right.
Your Lordship, my main grounds for challenging this writ petition, Your Lordship, is that the respondent number 1 did not issue any fresh advertisement. Your Lordship, the post being Magistrate First Class, Your Lordship, is a public post, Your Lordship. They had to follow by the due process of law, which was not followed.
Yes.
Your Lordship, in giving their appointments, the respondent 1 cited only few reasons, that is COVID reason and also due to lack of budget provisions for not issuing fresh advertisement, Your Lordship. 2 reasons was there. And also, Your Lordship, the Respondent 1 have written that 5 vacant posts was there in the year 2019, which is incorrect, Your Lordship, as is evident from the sanction letter. There
That
was,
will disregard, yes.
yes, Your Lordship. And also special consideration was given, Your Lordship, which is totally illegal.
So is the consideration given to?
Sorry, Your Lordship, to Respondent 4 to 6. It's there in their letter of 19 August 2021 also, that special consideration may be given,
No,
which was
but the
duly
thing is
allowed.
that they came through a selection process.
Sorry, Your Lordship.
They came through selection process.
Your Lordship, they have applied in the post advertisement recruitment year of 2019, Your Lordship, for the strength of 3 magistrate vacant posts. The candidates were already appointment and due serving till date. As such, there is no vacancy. Now, the appointment which they have got, it had to come from a fresh advertisement, which Respondent 1 failed to do so, Your Lordship. Which is not allowed in special in public employment, Your Lordship. Your Lordship, I would like to take you to the written arguments filed by me, Your Lordship, where I have cited some of the judgments, Your Lordship. Your Lordship, the Respondent 1 had filled the vacancies over and above the number of advertisement posts. The advertisement post was being 3, Your Lordship. Regarding that, Your Lordship, I would like to take you to page number 6, Your Lordship, of the judgment.
Your written argument is much thicker than the petition.
Cited few judgments, Your Lordship.
Okay. Yes.
Page number 6. It's 2012 5 SSC, page 559.
Page 6.
Your citation is 2012 5 SSC 559. This is the citation, Your Lordship. And page 6, Your Lordship, para 17.
Which is the first judgment referring to?
2012 5 SSC.
Okay.
Arup Das and others was the state of Assam.
2012
5
SSC.
SSC, page 559.
Yes.
Para number 70. Is there, Your Lordship, in the citation?
In the
yes,
compilation?
Compilation, yes, Your Lordship.
Okay,
Page
yes.
number 6, para 17, Your Lordship.
One second. Yes. Yes.
Para 17, Your Lordship.
Yes.
It is well established that an authority cannot make any selection/appointment beyond the number of posts advertised, even if there were a larger number of posts available than those advertised. Full stop. The principle behind the said decision is that if that was allowed to be done, such action would be entirely arbitrary and violative of Article 14 and 16 of the Constitution, since other candidates who had chosen not to apply for the vacant posts which were being sought to be filled could have also applied, and if they had known that the other vacancies would also be under consideration for being filled up. Your Lordship, this is one of the points. Even in para 19 also, Your Lordship, in a recent decision rendered by this court in State of UP versus Rajkumar Sharma, this court once again had to consider the question of filling up vacancies over and above the number of vacancies advertised. Full stop. Referring to the various decisions rendered on this issue, this court held that filling up of vacancies over and above the number of vacancies advertised would be violative of fundamental rights guaranteed under Article 14 and 16 of the Constitution, and that selects could not claim appointments as a matter of right. It was reiterated that mere inclusion of candidates in the select list does not confer any right to be selected, even if some of the vacancies remain unfilled. This court went on to observe further that even if in some cases appointments have been made by mistake or wrongly, that did not confer any right of appointment to another person, as Article 14 of the Constitution does not envisage negative equality, and if the state had committed a mistake, it cannot be forced to perpetuate the said mistakes. Your Lordship, this judgment is very much clear that the vacancies cannot be filled over and above the number of posts. Your Lordship, another argument would be the waiting list which was issued by Respondent 1 cannot be used for fresh appointment, Your Lordship.
Yes.
Your Lordship, and it is not a source of recruitment also, Your Lordship.
Where is that judgment?
Your Lordship, the judgment is Kumar,
At the time when they were recruited, were the rules framed? Rules are there now.
Your Lordship, that's a good point, Your Lordship. Recruitment rules are not framed, Your Lordship, till now.
Then the High Court directed at one point of
Yes,
time
Your
that
Lordship.
rules be framed. What happened?
The division bench of this Honorable Court directed the Respondent 1 to frame recruitment rules within 2 months, but till date they have not framed recruitment rules, Your Lordship.
So there's no...
There is no recruitment rules, and also, and in the absence of recruitment rules, Your Lordship, the Respondent 1 cannot make any action, cannot take any action with regard to appointment at any point of time. That is a settled law, Your Lordship.
What are recruitment rules?
Without recruitment rules, they cannot give any special consideration or any special, it has to be any recruitment rules, giving them powers to amend the advertisement or amend anything, Your Lordship. Okay. In the absence of them, they cannot do. Your Lordship,
okay, next judgment you want to do, please?
Yes, Your Lordship. Apurva Kumari. Your Lordship, page 56, Your Lordship, of my compilation. This is a Bombay High Court judgment, Your Lordship. Apurva Kumar and others versus Institute of Banking Personnel Selection and others.
Page?
Page 56, Your Lordship.
Yes.
The relevant para will be para 14, which is at page 72, Your Lordship. Yes, Your Lordship, of my compilation.
Oh. Para what?
14, Your Lordship.
Para 14.
Yes, Your Lordship. May I read, Your Lordship?
Yes.
Apart from the above, one of the issue which needs to be answered is whether there is no absolute right in favor of the petitioners to claim appointment as a right. The said issue, in our opinion, is no more res intriga. The Honorable Supreme Court, in the matter of Sankarshan Dash versus Union of India, cited Supra, has already held that if name of the candidates appear in the select list, comma, he does not have absolute right in asking for appointment. Mere inclusion of candidate's name in the select list does not confer any right to be appointed, even if some of the vacancies remain unfilled. Full stop. The concerned candidate cannot claim that there is a hostile discrimination. The Honorable Supreme Court has observed that the select list cannot be treated as a reserve list for the purpose of issuing appointment, so that the vacancies can be filled up by taking the names from the list as and when, if so required. So here also, Your Lordship, in our case also, recruitment was given based on the waiting list, and waiting list is not a source of recruitment, Your Lordship. Your Lordship, the authority, next argument would be, Your Lordship, authority or government body cannot fill up vacancies for future, since in the affidavit, by implying that
yes,
by implying that the vacancies arose in the future, so they have already appointed that. Your Lordship, here now I'm taking you to another judgment, 1994, supplementary to Supreme Court SEC, page 591.
Supplementary to
SEC 591. It is there in my compilation, Your Lordship.
Yes.
Page 41, Your Lordship, of my compilation. Para 8, Your Lordship. Page 41, Para 8, Your Lordship.
Yes.
Page, Para 8 and 9, Your Lordship.
Yes.
Para 9, I would like to read. Para 9, a waiting list prepared in an examination conducted by the Commission does not furnish a source of recruitment. It is operative only for the contingency that if any of the selected candidates does not join, then the person from the waiting list may be pushed up and be appointed in the vacancy so caused. Or if there is some extreme exigency, the government may, as a matter of policy decision, pick up persons in order of merit from the waiting list. But in the view taken by the High Court that since the vacancies have not been worked out properly, therefore the candidate from the waiting list were liable to be appointed does not appear to be sound. This practice may result in depriving those candidates who become eligible for competing for the vacancies available in future. If the waiting list in one examination was to operate as an infinite stock for appointments, there is a danger that the state government may resort to the device of not holding an examination for years together and pick up the candidates from the waiting list as and when required. Full stop. The constitutional discipline requires that this court should not permit such improper exercise of power which may result in creating a vested interest and perpetuate waiting list for the candidates of one examination at the cost of entire set of fresh candidates, either from the open or even from service. Here also, Your Lordship, since the respondent one has filled over and above, and also they have filled the future vacancies, it is also debarred, Your Lordship.
Yes.
Your Lordship, they have violated Article 14 and 16 of the Constitution of India also, Your Lordship. If the respondent one would have issued fresh advertisement, other candidates apart from me also, apart from any all the other advocates could have applied in the said post, Your Lordship. For that, Your Lordship, I'm taking you to judgment of 2010. Volume 2, SCR 239, which is in page 8, Your Lordship, of my compilation. The relevant para would be para 14, Your Lordship, page 13. Page 13, Your Lordship. Para 14, Your Lordship.
Okay.
In view of the above, the law can be summarized to the effect that an appointment made beyond the number of vacancies advertised is without jurisdiction, being violatives of Article 14 and 16, subclause 1 of the Constitution, thus a nullity inexecutable and unenforceable in law. Full stop. In case the vacancies notified stand filled up, process of selection comes to an end. Waiting list, etc. cannot be used as a reservoir to fill up the vacancies which come into existence after the issuance of notification/advertisement. The unexhausted select list/waiting list becomes meaningless and cannot be pressed in service anymore, Your Lordship.
Yes.
Your Lordship, even in Gajanan Babulal Basunde versus and others versus State of Maharashtra, the Honorable Supreme Court had reiterated the same, that any vacancies which is filled over and above the number of persons, it has to be the waiting list. It comes to an end, Your Lordship. And Your Lordship, the respondent one, after filling up the vacant post of 2019, Your Lordship, they have selected the 3 candidates which are serving till date, Your Lordship. They have already closed, Your Lordship, the recruitment year. As such, the filling up the fresh new vacancies has encroached all others' right. Your Lordship, I'm taking you to another judgment, Your Lordship, which is of Jammu and Kashmir High Court, Your Lordship. Page 19 of my compilation. Para number 11, Your Lordship. Page 22. Para 11, Your Lordship, here I would like to refer to para 11, 12, 13, 14, and 16, Your Lordship.
Yes.
The gist of this, all this para, Your Lordship, it's the recruitment cannot be filled over and above the vacancies which is notified and which is violative of Article 14 and 16, Your Lordship. And also, Your Lordship, the waiting list cannot be used as a source of recruitment. It is only for the post, for the candidates who demits the office or if they demise during the service, Your Lordship. Then the waiting list has to be used, Your Lordship. Your Lordship, one more argument, Your Lordship. The respondents have said that they have already been served more than 1.5 years, Your Lordship.
Yes.
That cannot be a ground, Your Lordship, for an illegal appointment, illegal and arbitrary appointment. Here, regarding that, Your Lordship, one judgment is there, Your Lordship. Roshan Lal versus HP Power Corporation, Your Lordship.
Which page of compilation?
Yes, Your Lordship. Page 74, Your Lordship, of my compilation.
Roshan Lal.
Yes, Your Lordship. Roshan Lal
This is
versus...
all High Court judgments only.
Yes, Your Lordship.
No.
Para 40, Your Lordship.
Para?
40, Your Lordship. Your Lordship, if I may. Page 92, the relevant page would be, Your Lordship.
Yes.
I am not at all impressed by the submissions of the learned counsel. A person who has been appointing by throwing all the procedures to win cannot take shelter behind equity. After all, equity is not an empty concept. In fact, it tilts the balance when all other things are equal. An employee appointed throwing all the procedure to win and in breaches of Article 14 and 16 of the Constitution cannot take shelter behind equity. Once initial appointment is bad, then such person cannot be permitted to continue in service only on the ground that such person had continued in service for a long time would amount to giving premium to illegality and encourage corruption, Your Lordship. Here also the respondent 4 to 6 have taken this ground. The initial appointment is bad, Your Lordship. As such, they cannot take this ground that they have been serving for a long time, Your Lordship. And last argument would be, Your Lordship, that this Honorable High Court has directed the respondent to frame recruitment years in 2018, Your Lordship. But till date, recruitment rules has not been framed, Your Lordship. As such, I'm praying that the order I've annexed it, Your Lordship, in page 97, Your Lordship.
No recruitment rules.
No recruitment rules. Page 97 of my compilation, the order of this Honorable Court, Your Lordship. Division Bench, Your Lordship.
There are no recruitment rules till date.
It appears, my Lord. There are no
Sure.
recruitment rules.
Last argument would be, Your Lordship, in
The
2000.
process initiated only one person. Two people become vacant. These are quite a very cautious selection process. They want to frame recruitment rules. That means that you don't have recruitment rules. You're free to do whatever you want.
But I'll answer that argument. I'll answer
So because okay, fine. Because if there's an order, we direct respondent to immediately frame recruitment rules, initiate the process of recruitment of 3 vacant posts in accordance with rules that we frame. That means even the 2019 advertisement for the other 3 vacant posts also was not rules, so there will be non-essential law as per in violation direction of this code.
If that is the case, they have to implement them also, the first 3 appointees. And why they participated? They participated in the recruitment.
Participation is different, Your Lordship. A recruitment rule has to be framed by the respondent one.
No, but I'm sure there must be rules. No rules.
There's no rules still there, Your Lordship. There's no
You
rules.
sure?
Yes, Your Lordship.
We'll try to find out.
Where's Mr. Kintar? He's not appearing anywhere in this case. Oh, you Prince Counsel. Sorry. Yes.
Your Lordship, the last argument would be since this statement of showing the strength of the judicial officials, which was recently issued.
That's not necessary. We're going on
Your
a point
Lordship,
of law.
this is yes, Your Lordship. But still, Your Lordship, in 2019, only 4 posts was there. Show, the strength of magistrate, out of which, Your Lordship, one was duly served by Madam L.W. Fira. So as such, only 3 posts was vacant in 2019, for which the respondent one duly published advertisement, which is filled till date, Your Lordship. So as such, the appointment of respondent 4 to 6 is purely arbitrary and illegal. As such, I'm praying that their recruitment, their appointment may be cancelled, Your Lordship.
Yes. Rules are there.
We're trying to ascertain that. We're trying to ascertain.
Get it first. You can reply tomorrow if you want.
But I think by the time I submit, my Lord, we should be able to get there.
Yes.
My Lord, the first important fact, Lords will kindly note that both the petitioners were candidates.
How does that disable them from challenging the selection?
My Lord, it will touch upon many aspects of the entire matter, my Lord.
Okay. Yes.
Second important aspect, my Lord, that
both the petitioners took part in the selection
yes, Your
and
Lordship.
failed.
And failed, yes, sir.
Yes.
Second important aspect, my Lord, the written test was conducted. Only 6 candidates qualified in the written test.
Yes.
They were called for interview, 6 of them, my Lord.
Yes.
And based on the combined merit in the written test and interview marks, my Lord, merit list was prepared.
Yes.
The Lordship is noted, select list was dated to 11/1/2021.
11/1/21, yes. Merit list, yes. Like
Merit. And this was extended till 31/3/22.
Yes. Yes.
The Lordship
It's extended till
31/3/22.
Yes.
The 3 candidates, my Lord, who are the private respondents here, Lordship will note the dates, my Lord, when they are appointed.
Yes.
The first, the 4th candidate in the list, my Lord, was appointed on 28/2/22.
Yes.
The 5th one on same date, my Lord, 28/2/22. And the 6th one was appointed on 4/3/22.
Yes.
So all the appointments were made during the validity of the select list, my Lord.
Yes.
My Lord, third important aspect, my Lord, there is no allegation anywhere in the writ petition. And I don't think that is even the case of the petitioner, my Lord, that there was any kind of nepotism or any kind of irregularity, or they are unqualified candidates. There are no such allegations, my Lord.
Or any unfair
An unfair practice or irregularity or malafide or nepotism, there are no such allegations, my Lord. anywhere.
Yes. Yes.
So the only question that revolves around number of posts advertised, whether there were any anticipated vacancies at that point of time or not.
Okay, 1 second. Posts advertised, anticipated vacancies.
Whether anticipated vacancies could be filled up from the wait list or not.
Yes.
And if filled up, my lord,
Yes.
will that be legal?
Yes.
Well, I'm just trying to frame the questions, my lord.
Yes, yes.
And the next question will be, my lord, even if the court comes to a conclusion that posts could not have been filled up,
Yes.
will this honorable court unseat them at this stage, my lord? That's the last question, my lord.
Yes.
Now, your lordships has noted the fact that the facts that whatever the circumstances at that point of time, my lord, it was a COVID period.
Yes.
2021, my lord.
Yes.
Another important aspect, my lord, that the very small cadre, my lord. It is not like a MPSC or MCS where there is a big, large cadre, my lord. Annual vacancies have to be ascertained by a certain date.
Has it come on the affidavit?
Well, they are legal points I'm just trying to submit, my lord. Because these are the points raised by my friend are also not there in the writ petition also, my lord. Most of the points are not there. So, my lord, why I'm trying to submit this, my lord, in case of a large vacancies, my lord, large cadre strength, there are anticipated vacancies every year because of retirement, death, and promotion and other things, my lord. So, the Supreme Court in Malik Major Sultan case, I'll refer to that, my lord, has said that there must be annual vacancies must be determined by a certain date and advertisement must be issued by a certain date, my lord.
Yes.
Now, whether that can apply to a cadre, whether the total cadre strength is 6 or 5 or the vacancies arose after 10 years of 3 vacancies, my lord. Whether we can apply that, all those rules and...
The vacancies arose, last recruitment was done when? The last magistrate appointed in which year?
That's a long time, my lord. Must be 15 to 20 years back, my lord. Before this recruitment, the last appointment was...
But vacancies
period.
always there at that point of time after the... what was the cadre strength then at the time the last magistrate was appointed?
4, my lord.
No, when the last magistrate was appointed, there were 4 only.
4 only.
When was the last magistrate appointed?
Last magistrate appointed will be Madam Fira. That must be...
And she's been service how many years?
20 years now. Thereafter she was promoted, madam.
Oh, she's promoted now?
She's additional judge.
2023.
No, is she been promoted as?
Additional now, Your Lordship. 2023, after the retirement of the judge, Your Lordship.
Okay, I'm not aware of it. When did the judge...
August 2023, he retired.
Recently he retired?
Yes, Your Lordship.
Which was under extension, I think.
Sorry, no, Your Lordship.
For some time.
No more.
Finally he retired, madam.
Finally meaning?
After a few extensions, my lord.
Right.
So, my lord, to answer the suggested issues like what I suggested, my lord, the first question will be how many vacancies were there, clear vacancies on the date of advertisement, and the second question will be how many anticipated vacancies were there, my lord. So, we have stated, my lord, 3 clear vacancies were there on that day. There are anticipated vacancies, and that your lordship will kindly refer to is 35 of the writ petition, my lord.
$35.
My lord.
Yes.
My lord, this is dated 19th August 21 from registrar to registrar, my lord, and from Secretary Executive Committee.
Yes. 19/8/21. 21. Yes.
Subject approval for appointment so and so. I'll come to second paragraph, my lord. Yes. However, it may be informed that there are few more vacant posts of magistrate first class.
Yes.
As per current budget provision and in view of the current situation in the state and country as a whole, it may not be conducive to conduct fresh examination for filling up the said vacant post. The Executive Committee has, for strengthening the functioning of the District Council Court, recommended to fill up the remaining vacant post from the candidates in the waiting list. Moreover, there are many pending cases which require a speedy trial, and the Executive Committee is also contemplating to make the District Council Court functional in all the district headquarters, that is Nongstoin, West Kasils, Nongpur, Riboy and Mokirwat, Southwest Kasils. Therefore, it is once again requested that to fill up the remaining post, the candidates in the waiting list per notification so-and-so may, as a special consideration, be approved for appointment of magistrate.
Yes.
So, my lord, this is evident from this, my lord, on this date, there are anticipated vacancies and select list was still alive on that day.
Yes. Yes.
So, my lord, this in my humble submission will answer that anticipated vacancies existed on that day, my lord.
On as on 19th.
On 19/8/2021. And
2021.
this is recorded on that day, my lord. The anticipated vacancies existed even prior to this. This is only a recording or a statement of that fact, my lord. It is not that vacancy arose on this date, my lord. Vacancies arose prior to that.
Yes.
Now, my lord, pursuant to the approval, they were given appointment. Your lordships have stated the dates when they are appointed. Now the question comes, the last and most important question, my lord. Even if your lordship comes to conclusion that posts in excess of advertised number of posts could not have been filled up, my lord, the question is whether your lordship will unseat them at this stage, because there is no allegation of any other extraneous factor in the selection process, my lord, or even that they are not eligible, or there was a malified. My lord, in that regard, I'll place two decisions, very recent decisions of Supreme Court, my lord.
Yes.
But I'll take your lordship. I've given a compilation, my lord. This is Vivek Kaist versus State of Himachal Pradesh. I think it's second flag.
Is it reported?
By now, it might have been reported, my lord.
Big guys, this is a decision of 23.
My lord, November 20, 2023, the last page, lordship.
One second. It is not paginated anyway.
I'll refer to internal page.
No, yes, 1 second. Let me just. Vivek. Yes.
I'll take a lordship, para 21, my lord.
Yes. Yes.
Internal page 28.
20.
28, page number 1, para 21.
Yes. Yes.
I'll read, my lord. Appointments cannot be made over and above the vacancies which have been advertised, except in an emergency situation or for some unforeseen reasons in public interest, or when a policy decision is taken by the state government in this regard, as held by this court in Gujarat State Deputy Executive Engineer versus so-and-so, 1994 supplementary.
Yes.
Then, my lord, this case was also The facts of this case, my lord, there were appointments were in excess of number of advertised posts, my lord. Para 31, my lord. I'll read few paragraphs from this judgment, my lord.
Yeah,
this more or less covers our case, my lord.
Yes.
Para 31. In the preceding paragraphs of the present order, we have already clarified the position of law, and therefore, in our opinion, the High Court was right in holding this position, which is the settled position of law. What the High Court missed was the context, the facts, and circumstances of the case.
No, that is a, you see, even that case of Abdul Faisal, you must have seen it, that, even set principles are there, but law cannot be said in a vacuum. It has to be, the contextual. It has to be.
The facts and circumstances.
Yes.
So that's what para 31, my lord. Para 32, I'll just read a few paragraphs from here, my
lord. You have not made any allegations of any extraneous considerations come to play in the appointment? No.
Your Worship, we have said that it's totally illegal in nature.
No, illegal, fine. That is a general submission. Illegal, arbitrary, discriminatory, these are, they come like...
Nepotism, favoritism, or unfair process in the exam.
No, that's all right, yes.
Nothing is there.
No, all right, you sit down. Yes.
Para 32, my lord.
Yes.
A judge is a judge of facts as much as he is a judge of law. The position of law we have already explained in the preceding paragraphs, which has been correctly followed by Himachal Pradesh High Court. Now let us see the context of the case and its facts. Today, when we are delivering the judgments, the two appellants have already served as judicial officers for nearly 10 years. Meanwhile, they have also been promoted to the next higher post of civil judge senior division in this process of their selection and appointment, which has obviously benefited them. Nothing has been brought to our notice which may suggest any favoritism, nepotism, or so-called blame as to the conduct of these two appellants in securing these appointments. The High Court, in fact, noted this factor. While placing the blame on the State Commission, it records that there is nothing on record suggestive of the fact that any malafides were behind the selection of respondent number 4 and 6. The two appellants had qualified the examination ever in the merit list. Should you quash their appointment and unseat them from judicial service is the question. The same question was here before the High Court, and it expressed its inability to protect the appointment of the appellants for two reasons. The first reason was that since it had determined a finding on illegality in the appointment, it saw no reason to continue with these appointments on the ground of hardship and equity, as that could be done only under Article 142 of the Constitution of India, and these powers the High Court did not have. The second reason given was that in any case, the balance of equity would lie in favor of the petitioner, that is Respondent 4 before the High Court, and not the present appellant. The reason given were as follows. I'll skip that part. Para 34. The appellants were not entitled to an equitable relief in view of the High Court, as they were the beneficiary of an illegality committed by the selection appointing authority. But then it failed to take this question further, which in our opinion, it ought to have done. What the High Court never answered was as to how much of the blame of illegal selection appointment would rest on the High Court on its administrative side. Undoubtedly, with all intention of timely filling of the vacancies, the High Court still cannot escape the blame. From the very initiation of adding future vacancies after the select list was published, the High Court has been privy to the selection appointment process. My lord, in this case, the district council courts are not directly under the control of High Court, my lord, so we may skip that part also. Para 35, my lord.
Yes.
Having gone through the pleadings of the appellants and that of the respondents, we are of the considered view that there has been a violation of the process in making selection appointment of the appellants, in as much as the vacancies on which the appellants were appointed were never advertised, and strictly speaking, these vacancies cannot be termed as anticipated vacancies for the simple reason that these vacancies were only created on 18/4/13 after the selection process had begun and advertisement was issued on 1/2/13. What is also important for our consideration at this stage is that the appellants in the present case have been working as judicial officers now for 10 years. They are now civil judge. These judicial officers now have a rich experience of 10 years of judicial service behind them. Therefore, unseating the present appellants from their posts would not be in public interest. Ordinarily, these factors, as we have referred above, would not matter once the very appointment is held to be wrong. But we also cannot fail to consider that the appellants were appointed from the list of candidates who had successfully passed the written examination and viva voce, and they were in the merit list. Secondly, it is nobody's case that the appellants have been appointed by way of favoritism, nepotism, or due to any act which can even remotely be called as blameworthy. Finally, we have now been working as judges for 10 years. There is hence a special equity which leans in favor of the appellants. In a recent Constitution Bench decision of this court in Sivanandan City, another was High Court of Kerala, so and so, though the finding arrived at by this court was that the rules of games were changed by the High Court of Kerala by prescribing minimum marks for the viva voce, which were not existing in the rules, and therefore, in essence, the appointment itself was in violation of the rules. Yet, considering that these persons who had secured appointments under this selection have now been working for more than 6 years, it was held that it would not be in public interest to unseat them. It was stated in para 58 agenda. So, read para 58.
And that's it.
So, my lord, taking this aspect into consideration, my lord, that it is not in public interest to unseat them. Even if the lordships come to a conclusion, our case is that there were anticipated vacancies, and moreover, one extra factor that leans in favor, my lord, in the district council's favor, is that the COVID situation, my lord. It was absolutely impossible to hold a fresh recruitment process during that period, my lord, during the period under consideration.
Yes.
But the second decision which I've annexed there is the Sivanandan versus City, that is a constitution based decision, my lord, which is referred to in this decision, my lord.
That is the compilation.
The compilation is not reported.
My lord, this judgment is there in my affidavit also, my lord. 2023 SCC online, SC 994.
1 second. Yes, no, I got it. Yes. What is the citation? 2020?
2023 SCC online, SC 994.
SC 994.
My lord.
994. Yes.
So what is important is para 58 only, my lord, from you. The question now.
58. Sivanandan City.
My lord.
There's no para 58.
Para 58 is at page 56 of the affidavit, my lord. My counter additional affidavit.
This one you given, there's no para 58.
But Sivanandan.
Yeah. The reported one is annexed in the affidavit.
Wrong judgment is citing.
The one judgment is correct. One is the directive from Supreme Court's website, my lord, and one is from SCC online. I think there is variation in para numbers, my lord.
How does the paragraph start?
It is the question which now arises.
1 second. Yes, that's paragraph 53. Yeah, what should this court do?
Yes, my lord. The question which now arises for this court in regard to the relief.
Yes. Yes.
Now, my lord, now the subsequent developments which
no, but this is a different case, because in this case these other candidates also they said that if the marks were computed a different way, they would be higher than the candidates who were selected.
In this case?
In this case, yes. I mean, they have a much better case. That they pass also selection, and then they said if the computation is done again.
The rules were changed after the advertisement.
Yeah, the rules were changed after the advertisement, and so they would have
but
ranked
still,
higher.
Yes, my lord. But in spite of that, the Supreme Court took that view, my lord. Now, my lord, the subsequent development is that, my lord, what is their case? They want to participate again in the selection process, my lord. That can be the only intention of the petitioners, my lord. It is not a PIL. My lord, one vacancy is already there, my lord. As an equitable relief, my lord, because they have come before this honorable court, my lord, we'll advertise that post. If lordship grants us liberty, we'll condone their age, my lord, if their time is barred, my lord.
What's the age? Age limit how much? Is the age limit 5 years?
There was age limit, my lord. Advertisement.
With ST concession, you can till
my lord, I think in spite of that, they are over age, my lord.
37 and 34.
How old is she?
She's 37, 37 and another one is 34.
So 37 will be time barred, overage, my lord. So as a equitable consideration, Lordship can, if grants us liberty, my lord, will advertise one post, they can participate, my lord.
No, why? If they are not, if they have not mirrored the case and they have not, they are barred by age, why should you give them equal relief?
My lord, that is your lord.
Equity follows the law.
My lord.
Law can't follow equity.
My lord, that much, if Lordship directs us, we can concede that, my lord. That's my proposal.
Yes, who's appearing for the state? You finished? That's it, Dr. Masika.
My lord.
Yes.
My lord, only to sum up, my lord, the law that has been placed, and in Vasisht, that judgment I cited, it says, my lord, that in emergent situations, additional posts can be filled up from the waiting list, which I referred to the first paragraph.
No, but you have not really addressed the point, anticipated vacancies and clear vacancies.
But clear vacancies were 3, my lord. And anticipated vacancies were 3.
Subsequently, anticipated vacancies, or there is.
Well, page 35, that's why I pointed out, my lord. It says that 3 more posts are available, my lord.
There is 3 more posts, some posts.
Some posts, it says, my lord. But Lordship can gather that there are 3 posts available, my lord.
So some posts will mean that other 4 posts
because
are there also.
Because one post
that
was.
Means if there were 4 people in the waiting list, that all the posts have been filled up by now.
Would have been filled up, but only 6 qualified in the written test, my lord. Only 6 qualified the written test, my lord. They did not qualify.
No, that'll go against them. They're not qualified. I mean, that is all right. Only the question, they're just questioning the selection process. That's all, without any other. They're just saying that if there are other clear vacancies, they could have. I mean, if there were other vacancies,
they should have.
Then the selection process, it was concluded with the merit list being published, and since the officers selected have joined, and so the waiting list also loses its life. That's all.
And if there is any fresh vacancies, then
in my humble submission, because of the COVID situation, the normal rules.
What about see, this is a council now. What is the method of? Are they bound by? There are no rules. Have the rules there or not?
Been framed is pending before the governor for assent.
Rule 7 framed is pending before the governor for assent.
Do you have a draft rules?
It's framed after the High Court order.
We can get the draft rules. We can place it. We can place it, my lord.
Let us see the draft rules also. It'll be interesting to see the mind of the.
My lord.
But that means anyway. But the draft rules won't have any effect. But it means that it's without the rules being, there are no rules in place, that gives you more latitude.
Not only that, the COVID also gives us some extra latitude.
Yes.
And another relevant factor was that the district council was proposing to set up benches, my lord, in 3 districts. That has come in that letter itself. And it is a fact that 3 benches are functioning now, my lord. If Lordships interferes with the appointment, those 3 benches, my lord, will again be under cloud. In fact, all these 3 subsequent appointees are there on those 3 benches, my lord.
Yes. Yes, sir.
This is Your Lordship. Lordship, I'm adopting the submission advanced by the District Council, Your Lordship. Then I would also add, Your Lordship, that there is a suppression of fact, Your Lordship, because admittedly, Your Lordship, the writ petitioner took part in the selection process, but they have never disclosed that
in the writ petition.
In the writ petition.
Once, they have not disclosed. You have not disclosed that writ petition that you took part in the. Why?
I have gone through the writ petition. They have not. They have not.
You have never not said it anywhere.
They have not said anywhere, Lordship. I have gone through the.
Your Lordship, since we were challenging the appointment of.
No, I mean whatever it is, you're projecting sort of fresh candidates who were not given opportunity at all.
Disclosed that fact.
There's a big difference. The difference is that now, the thing is that suppose there are certain persons interested. Okay, they have not been selected. They have not offered a candidature also. They're waiting for subsequent vacancies to arise. But they're not eligible or something for a reason. You should have disclosed that.
They should have come with a clean hand, Your Lordship. Yes. Those who seek equity, Your Lordship, who seek relief, because 226 proceeding, Your Lordship, is equitable relief, Your Lordship. They should come with a clean hand, Your Lordship.
Yes.
So far,
you got from RTI how much marks you scored?
Your Lordship, we have not obtained that, Your Lordship.
You asked for it?
No, Your Lordship. No, Your Lordship.
No.
So far, the case law, Your Lordship, we are relying the same case law, Your Lordship.
Anything else?
That's all, Your Lordship.
Then private respondents. Any July 4 respondent number?
2 and 3, Your Lordship.
Yes, and then
Private respondents, more 5 and 6 months. I am adopting the submission response of my colleagues. And my lord, here, in addition to that.
now you appointed, you 22 you took office.
Yes, my lord. We have
22.
Yes, my lord.
Yes.
Now, my lord, the petitioners, my lord, the writ petition is also hit by delay in latches, my lord. They have not come to the court at the first available opportunity, my lord. In fact, they have waited, they filed a petition, subsequently they withdrew it, and then filed a fresh petition, my lord. Secondly, my lord, their approach is half-hearted. They nowhere prayed for a stay of the appointment, my lord. Of course, by the time they had come, appointments were already beat. There was no interim prayer to that effect.
There was miss case, correct? You filed for interim?
Your Lordship, we have made in writ petition one of the bearer.
No separate miss case was filed, my lord.
In the writ petition, we have prayed for during the pendency, the respondents 4 to 6 may be restrained. Is there in prayer number 6, Your Lordship? Is there in my writ petition?
However, my lord, no separate miss case was filed, as is the procedure here in this. The procedure prevalent in the High Court.
No, once a person appointed, also there's no question of stay.
Thirdly, my lord, the position of the private respondents, my lord, is now cemented with the passage of time. My lord, the decision relied upon by the respondent number 1, my lord, I have also relied on that decision, my lord. The case of Vivek Kaist squarely supports our case. Squarely supports our case, my lord. In Vivek Kaist, the Honorable Apex Court has held that a judge is a judge of facts as much as a judge of law. My lord, meaning thereby that while giving paramount consideration to law, the judge cannot be oblivious to the facts. Now, my lord, in this case, my lord, it is not their pleaded case that we are in any way disqualified. My lord, it is not their pleaded case that there were any external consideration in our appointment, my lord. Their only case is that there has been that they are aggrieved because there has been violation of their rights enshrined in Article 14 and 16 of the Constitution of India. Now, my lord, here in a case of this nature, my lord, the court has to strike a balance between public interest and vis-a-vis rights of the petitioners before their lordship. Now, my lord, in Vivek Kaist versus the state of Himachal Pradesh, my lord, what had happened is appointments were made in excess of advertised post, my lord. In fact, the subsequent post that was advertised was the subsequent post which was sanctioned after the advertise was notified, my lord. Now, there, my lord, the Honorable Apex Court has said in paragraph 41, 42, and 58, my lord, in my written submissions, I have reproduced the relevant paragraphs, my lord. I'll just read paragraph 41, my lord. Vivek Kaist versus State of Himachal Pradesh, 2023 SCC Online, SC 1485. Having gone through the pleadings of the appellants and that of the respondents, we are of the considered view that there has been a violation of the process in making the selection and appointment of the appellants, inasmuch the vacancies in which the appellants were appointed were never advertised, like in the instant case, my lord. And strictly speaking, these vacancies cannot be termed as anticipated vacancies for the simple reason that these vacancies were created only on 18/4/2013 after the selection process began and the advertisement was issued on 1/1/2013. What is important for our consideration, paragraph 42, my lord, is that the appellants in the present case have been working as judicial officers for now for nearly 10 years. They are now civil judge, senior division. These judicial officers have rich experience of 10 years of judicial service behind them. Therefore, unseating them Therefore, unseating the present appellants from their post would not be in public interest, my lord.
Yes.
My lord, here for the last 3 years, 2.5 to 3 years, my lord, they have been discharging judicial functions on day-to-day basis, regularly passing orders, my lord. So therefore, my lord, it is not, despite the flaws in their appointment, my lord, so it is not in public interest to unseat them at this stage. Therefore, unseating the present appellants from their post would not be in public interest. Ordinarily, these factors we have referred to above would not matter once the appointment is held to be wrong. But we cannot fail to consider that the appellants were appointed from the list of candidates who have successfully passed the written examination, my lord. Squarely our case, my lord. We had passed the written examination, that is why we were in the waiting list and viva voice, and they were in the merit list. Secondly, it is nobody's case that the appellants have been appointed by any favoritism, nepotism, or by any act which can remotely be called as blameworthy. Finally, they have now been working for judges for 10 years. Hence, there is a special equity which works in their favor, my lord. So, my lord, their case, the petitioner's case is that there has been violation of procedure. The due process as prescribed by law has not been followed. However, my lord, considering this, the special circumstances, my lord, public interest would not be served, my lord. If the appellants...
What's Abdul Faisal citation? That case is regarding that Jammu Kashmir IS officer. Yes, I am very bad at citations. Yes, sorry, continue.
So, my lord, our case stands on a similar footing, my lord. So, therefore, my lord, my submission is that, my lord, despite the fact that there have been flaws in the appointment, admittedly,
will not disable the appointment.
It will not be in public interest to unseat the private respondents. That's
Any
all.
reply? Yes, Your Lordship.
Yes.
Your Lordship, the first reply would be that in my petition I have not written that the select process was due to anything. Your Lordship, para 29 of my writ petition, page 23. Para 29, Your Lordship.
Yeah.
The petitioner says that the entire selection/appointment process is vitiated due to fraud and manipulation by
that you have to substantiate. You can't make bold allegations. You are a lawyer, you know very well.
Yeah.
No, you can't. That you can make a statement, but then if you make an allegation, that has to be. If you make once you say malified.
Yes, Your Lordship.
You see, it was vitiated by fraud and manipulation. Then you have to substantiate it in some manner.
Okay, Your Lordship.
And also, if you can ascribe some responsibility, like if you allege malified, then you have to make the person who you allege has made a malified person by name. That's the thing.
Okay. Your Lordship, one more thing. Respondent number 1 said that it was the waiting list was extended, Your Lordship. The waiting list was extended after the approval, Your Lordship. It was not before the approval. So as such, this submission also, it's not...
waiting list extended because the select list life was for 1 year.
Yes, Your Lordship.
So if they could have been appointed during 1 year, there is no problem. But then they extended after till March.
Yes, Your Lordship. Your Lordship, even if the waiting list extends for 5 years also, it will not have any repercussions, Your Lordship, because the candidates are already serving till date, Your Lordship. As such, and also, Your Lordship, Respondent 1 said due to the COVID reason. Your Lordship, the approval letter, Your Lordship, is dated 19 August, Your Lordship. That time, Your Lordship, in my humble submission, no COVID restrictions was there, Your Lordship.
That is 19/8/21.
Yes, Your Lordship. Page 35 of my writ petition, Your Lordship.
Yes, okay.
Where they have said that there are a few more vacant posts, and as such, it is not conducive to conduct fresh examination. Your Lordship, that time, even our High Court was functioning physically, Your Lordship. As such, there was no COVID restriction. So this stand taken by Respondent number 1 does not lie, Your Lordship. Other exams also were being conducted, Your Lordship, physically. As such, only for issuing...
Which other exams have been conducted physically?
Your Lordship, UPSC exams and other exams also, Your Lordship. That time, no COVID restrictions in my humble submission, Your Lordship. And Your Lordship, they could have issued advertisement, Your Lordship, on this date. An exam could have conducted in the subsequent year. When their approval, when their appointment was given in the month of February and March, Your Lordship, 2022, there was no COVID at all, Your Lordship. So the exam could have been conducted at that point of time. Whereas they chose
COVID 22?
No, there is no COVID in 22, Your Lordship. Your
I
Lordship,
think from personal knowledge, that's not true. My entire family got COVID in February 22. So.
But Your Lordship, there was no restrictions issued by the government, Your Lordship. After 2021, there is no restriction issued by the state of Meghalaya.
We'll pass orders then.
Your Lordship, I would like to say two more things, Your Lordship. The decision which is relied by Respondent number 1, Viveka, Your Lordship, here, in that case, Your Lordship, it is totally entire different facts. There the candidates were serving for 10 years, Your Lordship. Here in our case, the candidates are serving for 2 years and 2 months, Your Lordship. The first 2 years
2 years, 2 months.
Yes, Your Lordship. And first 2 years are probation period, Your Lordship.
Okay.
So as such, that also is there. Your Lordship, another decision which it is written. Your Lordship, another decision which Respondent number 1 has cited, Your Lordship. This one. Where is the new one? And this one. Which one? Your Lordship, the judgment which is cited by Respondent 1, Sivanandan, Your Lordship. Your Lordship, in this case also, proper recruitment rules was framed that time, and they were given duly appointment as per the advertisement. It was during the select process, Your Lordship, the recruitment rules was changed. As such, you
see, if there were recruitment rules, your case would be much better. So then we can put it straight against recruitment rules, whether they violated recruitment rules or not. But in this case, they have that to slip around because that's the only thing. That's why this court asked whether recruitment rules were filed, because this court had issued orders for framing recruitment rules.
But in that case,
if the rules were present on that day, they should be followed in letter. And if there is any violation, then whatever it is.
But Your Lordship, even in the absence of recruitment rules, it's the fault of the Respondent number 1, Your Lordship. It will not affect my case also.
Broader aspect of Article 14 and 16. That's all. That's a case you have made out also.
Your Lordship, and one last to Your Lordship, the case which has been cited by Respondent 1 and which has been adopted by other responses, Vivek Kayal, Your Lordship, the same judgment, para 35, Your Lordship.
Yes.
Para 35, if Your Lordship may be permitted to read. Having gone through the pleadings.
1 second.
Yes, Your Lordship.
Where is that?
Vivek.
Yes.
Para 35, Your Lordship.
In the case at hand.
Yes. Huh? No, Your Lordship.
In the case at hand, it's clear appointment of the appellant so-and-so was made on posts which were not advertised, and in fact did not exist at the time this one was made. An anomaly made, the second of this is quite apparent. In this case, there you see, you read 35, it says appointment was made on posts which were not advertised and did not exist also.
Your Lordship, having gone through para 35. No, you're not in the follow. Yes, from Google. I've just downloaded it.
Having gone through? Yes, para 41, yes.
Oh, yes, Your Lordship. Having gone through the pleadings of the appellants and that of the respondents, we are of the considered view that there has been a violation of the process in making selection/appointment of the appellants, inasmuch as the vacancies on which the appellants were appointed were never advertised.
Yes.
And strictly speaking, these vacancies cannot be termed as anticipated vacancies. for the simple reason that these vacancies were only created on so-and-so after the selection process had begun and the advertisement was on so-and-so. So, Your Lordship, as submission of the respondent one, that it is an anticipated vacancies. In my humble submission, it is not an anticipated post, Your Lordship. It is a fresh vacancy which they ought to have been advertised. And it is also not my case that I did not participate, Your Lordship. My only contention before this before this honorable court is that they were given appointment without any advertisement.
Right. That's it. Reserve judgment, yes.
Yes,
Let me look for do my own research also. You got a citation, Abdul Fasal? Why?
Is it IAS or deputy superintendent?
For what?
Please.
Oblige, Your Lordship.
Item 17. 17.
Please, Your Lordships. This is the matter, my lord, involving the customary practice. On the last occasion, Lordship take note of a inquiry report, my lord, submitted by them. We have inquiry report. Some kind of inquiry was held, my lord, in the Elaka Rimbai regarding the customary practice. So that was submitted by them. Lordship wanted to know about the decision taken by the District Council. Well, that relates to 73, my lord. Some of the file could be retrieved, my lord. I have gone through. But we require some more files.
What about the book that Mr. Nobody produced out of his pocket?
My lord, my lord, that
going back to 1500. What do you have to say about that?
No, but that also will go through, my lord, and that inquiry report, my lord, whatever decision the council has taken, my lord, that is also relevant. Part of the file have been retrieved. Some we are still, my lord, looking for. So, Lordship, short 10 days time you can ask for.
Regarding the inquiry report, my lord, we have received it through an application, my lord, and then copy of the applications, my lord. I'll give a copy.
I do not know what
we
is
have
this.
received it through applications file, my lord.
No, we are not denying, my lord. There is not an inquiry. There is an inquiry. We are not refuting that.
Where's the reply?
This is the reply, my lord. This is original copy of the.
You file it?
This is inquiry report.
Inquiry.
He has filed already.
We have already filed, my
He has
lord. That
filed
is
it,
part
my lord.
of my.
What your lordship wanted to know, my lord, what decision the district council has taken, my lord.
Okay, okay.
That is the thing, my lord. So we have retrieved some of the file ones. Some more files are.
Okay, when should we have it?
10 days, lordship.
Yes, Mr. S.N. Leonard Council appearing for the EDC submitted that the what is that? It's not recorded in order also. That 2 weeks time further is required to obtain a complete complaint to obtain
relevant records, my lord.
To obtain the relevant records since they relate to the year of 1973. Stop. Accordingly, prayers allowed just after 2 weeks. Yes. You kindly bring.
No, I'll part of the record I have.
And Mr. Nobody, you give copies of the books.
Yes, Lord. I have signed it. In fact, I'll just hand over a copy to the court master.
Yes.
All right.
Is it Khasi or is it Panar?
Khasi book.
My lord, regarding that book, my lord, regarding this book, my lord, we have objection because a lot of the information which was given there, my lord, that is misinformation, my lord, and 3 of the petitioners, my lord, their name also been reflected there, and what was asked to them and then what was written totally different, my lord.
No, doesn't mean you place reliance on the book. It's just to get,
Yes.
Light or darkness, we don't know. Yes, where's Mr. Deb?
18.
Lordship, on last occasion.
So you're ready to take the liability also?
No. My client is saying that she's not willing to accept the proposed settlement.
Now look at the proposal now. What about liability? Now, since you're seeing the wife, you have to bear the debts and the liabilities also. If they give you 1 lakh, then see, now they've got notice from the bank. This is last order. You're not seen.
No, I have not. Sorry.
Then, you look at last order.
My apology, Lordship.
You have not looked at last order before coming. Read this order. You not read the last order.
Lordship,
The duty of
my
lawyer
mistake,
before he appears every day in the court is to see what is the last order passed by the court.
My apology, Lordship.
So your whole case taken a twist now.
As it is, neither legal right nor the statutory rights was there. In spite of that, we were trying to help her.
Yes.
Now the
Now
liabilities
they've
has
been
come.
given a demand notice. Now we will allow your case to that extent.
Lordship. So, in Lordship, Lordship, I pray for time, Lordship.
What are you going to do now? You'll accept if your case is turned, Mr. Dev.
Yes,
Now
Lordship.
deaths and securities you are claiming. Deaths because succession is deaths and securities.
Lordship, true, Lordship.
Now if this poor lady is saddled with the 9 lakh, now that your husband took.
Lordship.
What to do?
Lordship, I may be allowed some
You'll
time.
you'll help them with some.
I may be allowed some time. Yeah.
Because the interest is increasing every month, my lord. That is the thing.
I may be allowed some time, Lordship. I was
Now,
not
even the offer they've made won't be able to give you any more, so but they have to service this debt.
Lordship.
Okay, Mr. B. Dev prays due to the developments.
Yes, Lordship.
Certain developments, Mr. B. Dev prays for allowed 1 week's time to obtain such.
All right.
See how it happens. You've taken that time, finished.
Lordship.
20. Item 20.
Yes.
My lord, that this is with regards to the grant of the disability pension, my lord.
Yes. What instruction? He said you will take instructions how much you're 60% disabled.
Yes, ma'am.
And when did you take off from service? When did you
My lord,
deported from service?
I entered into service in 2nd January 1975, discharged from the service 2nd January 1978, my lord.
46 years now.
My lord, even the discharge order. The discharge order itself says that he is fit for re-enlistment in Assam Rifle. My lord, if
No, whatever it is now.
My lord.
When did you file that petition?
My lord, we filed in
22.
my lord.
Before that, what did you do?
My lord, before that, I was surviving.
No. What do you do? You didn't approach authorities at all.
We approached, my lord. Representations
Regularly.
are there. Regulars are there, man. Representations are there, my
Why
lord.
did you file a petition at that point of time?
My lord, that time money was also not there, my lord.
Who was not there?
Monetary consideration, my lord.
78.
My lord.
Arguing some other time.
No, exactly. This court said whether you can make a package for him. Give him some monetary relief. Of course, after 1978 coming now, it's...
My lord,
Yes, enlisted on 75, they of discharge on 70, total 3 years. Total
18
service
days.
3 years only. What to do? But he got invalid pension, no?
No.
No, man. He only got service gratuity. Only.
That's all.
In such cases, what to do if they come after how many years?
My lord, interestingly, my lord, the respondent author, that's why the judgment which I have relied, Uttarakhand, my lord, that has been implemented by them, my lord.
We are not born by Uttarakhand.
My lord, even this coordinate bench, my lord. My lord, the
30
judge-
years old.
My lord.
Yes.
Judgment of the coordinate.
30 years old case.
My lord, 1951.
Which case is that?
51, disabled pension.
My lord, where you have filed an appeal which are withdrawn.
Oh no, this is different. This is family pension.
Family pension, my lord, is still 51 years, my lord. He is from 1951.
No, he was entitled to this.
My lord,
The entitlement was there.
My lord,
only that she did not come forward because but it's a continuing right. The family pension they should have got. This is a different case altogether.
my lord, even here, my lord, the disability pension, the petitioner is entitled
But then
for that.
see, if entitlement is already established and not granted, then the continuing right is being violated. But if that right is not established also, and then like there nothing to show that there was any consideration.
My
then
lord,
after coming after 78 in 2022.
My lord, after the respondents say that there is a minimum qualifying service of 10 years has not been fulfilled. My lord, that has been already been, Government of India has waived that, my lord, that notification.
That's what we're saying. Give you some package.
My lord.
Instead of dismissing your case on license and delay. You can't give a package.
Instruction.
But the difficulty, there may be many such cases. They'll start coming after 40, 45 years. Because we maintained record only for 20 years. What was the disability? How much was the disability? It's very difficult to ascertain.
Why you didn't come earlier?
My lord, the petitioner...
You're disabled, that's why.
My lord, how can he's from the Gorakhpur, my lord.
Gorakhpur is a city.
My lord, city coming here in Shillong, my lord, his instruction is from the my lord.
We understand your difficulty, but you see, if there's a certain amount of delay, but delay of a lifetime. That anyway, is it possible?
Well, departmentally also it becomes difficult to take a decision on this kind of thing.
Because it's taking into account the fact that notwithstanding the delay, that see the period of qualifying services for disabled it's been
waived off.
Been waived. There's a decision of the Government of India decision, correct?
Waived from 2021, my lord.
From 21 only. Mr. Jha, you prepare, you argue it in full, bring some more decisions. And also, Dr. Mozika, bring authorities, we'll see. Because on the face of the record, no relief can be forthcoming.
My lord, the relief can be granted, my lord. It is the department who is taking a pick and choose, my lord. Recently, my lord, they have given to some of the petitioners, my lord, lump sum pension, my lord.
That's why it is.
My lord, it is, order is there, my lord.
You already filed it?
No, my lord, it's recent one, my lord.
Let's see where they give lump sum pension.
My lord.
Let's see the document. That's why the school saying give a package to him. Yes, see. See, Dr. Mozika, this might help him. Let him get examined by medical board. Why don't you take this on the first place?
But there is no determination of pension. It only says, hence you are advised to report to Assam Rifles so and so hospital.
Exactly, there's no determination, but they can determine, they can give a notional if he had one discharge from service on that day and he was given disabled pension, then doesn't mean you can give 10% or whatever is due also.
I'll have it.
Court will mold the relief. Yes, in the course of the hearing, Mr. Arjha, learned counsel for the petitioner, has produced what is this, an order?
It's the order.
An order dated 1/11/2023, issued by the, who is this person?
My lord, it's a,
who is he? What post? What post is this?
The person, the petitioner, my lord.
No, this person who signed the letter. Which post?
OIC disability.
Yes.
It's a pension department.
Officer in charge disability has produced a letter, absence order issued by the OIC disability, then pension stroke NE capital comma record branch Directorate comma Directorate General Assam Rifles, wherein grant a one-time lump sum compensation of disability element has been granted to one Bal Chand, resident of Gorakhpur. You're from Gorakhpur only?
No, my lord.
You're from?
Gorakhpur. I am from Gorakhpur. Same, my lord.
He's a co-villager?
Gorakhpur.
Yes.
Because Assam Rifle has an association, my lord. Assam Rifle ex-servicemen.
As instant case also involves the claim for disability pension by the writ petitioner, perhaps this communication might be of some assistance to ascertain his rights or entitlement. Stop. Next paragraph. Mr. Dr. M. Mozika, learned DSGI, is directed to seek instructions as to whether similar concession can be given to the writ petitioner. Yes. Listed after 3 weeks. Given him a copy of the letter?
Given.
Yes. Copy of the letter, a copy of the order date 1/11/23 is taken on board, yes. Yes.
21.
So that can, I had the mind, only I didn't know that it existed also that we could have a lump sum pension. Yes. Yes.
Your Lordship, in this case, I need some time to produce the record.
You always need time.
It will come from Manipur, Your Lordship, so that's why.
This is that dual marriage matter, discharge from service. Court of inquiry.
Yes, further 2 weeks granted to Mr. Debnath to obtain the records, to produce records rather. Yes.
27.
Yes.
My lord, this matter was placed before the Lok Adalat last time, my lord, but unfortunately the petitioner could not attend. It appears that this matter is settled. So, my lord, I am praying for some time.
Settled?
I don't have any instruction, Your Lordship.
It came up before the Lok Adalat. The petitioner unfortunately was not present, my lord, because she was informed very late. However, the respondents were there, my lord.
Response whom? The commandant?
My lord.
Very short repetition.
My lord, a very innocent prayer
Only
is
you have
here,
to
my
furnish the details of
Yes,
death
my lord.
security. Have you furnished that? You can't furnish that.
Contrary to that, they filed an affidavit where,
We
my
filed
lord,
the
they have
affidavit,
decided
we are
my
saying that's,
title
you
as a
receive-
civil court, my lord. I'm only asking them to furnish the details. That's all. Thereafter,
You furnish the
the
details?
court will decide, my lord, whether I'm entitled or otherwise.
We file our affidavit, Your Lordship.
Doesn't matter. I'm asking you. You're speaking or affidavit speaking? You let affidavit speak, then we won't hear your submissions. You can sit down. We'll hear your affidavit only. See, Mr. Debnath, trying to find a why media to settle these matters, especially matters concerning pension. Oh, you're saying that the prisoner was married to the deceased employee?
Yes.
My lord, In support thereof, my lord, they have.
They have enclosed Measure 5, see.
They have
That's why
enclosed.
he said, let the record speak. He said he's never given that he was married.
They have enclosed a document of dated 1987, my lord. My case is that I got married to the petitioner after the death of my first husband. That is the case, my lord. And now,
when? After 87?
My lord. After 87, my lord.
Then why was the name not entered in the service book?
On 14/3/1996, my lord, after the death of her husband. They have enclosed the kindred list of, which is also dated 1987.
Where is that?
1987. It's not my case that I was married in 1987. My case is
married in 14/3/1996.
1996. And I am only asking for whatever debts and securities is left behind by my deceased husband, my lord. Whether I am entitled to or
first
otherwise.
questioning the very fact you're married or not.
Yes, my lord. I'm
That's the
married,
only
my
thing. Where is that? Where's the 87 document?
My lord, I have enclosed a certificate.
No, not forget marriage certificate. About where the 87 you're saying?
My lord, I'm referring to their affidavit, my lord.
Yes, page.
This is page 9. That is the typed copy, my lord. This is dated 26 May 1987.
What does it say? What is this? Who's this Mungmati then? Wife?
My lord, she is deceased.
Your wife? I'm the wife.
The wife of
your husband's
my lord.
Ex-wife.
Yes, my lord. And and Antara Dam, she is the
divorce.
sister.
You'll receive.
Okay, yes, okay. Oh, that is why it's difficult for him to release the details. Nominations only for this person. She died.
Yes, ma'am.
When?
My lord, after the
Any
death-
issues?
My lord?
Any children born of the first marriage with this
children,
deceased employee?
No children.
So he married, wife died,
Yes,
then
my lord.
you, husband died,
My lord.
then he married you.
Yes, my lord. My lord, in fact, the facts here are
That was never entered in the
little-
service records.
No, my
How
lord.
many?
Never entered, my lord. Never entered, my lord.
Then be difficult for them how, except the marriage certificate.
Elusive.
Yes.
If you come to this page 13, Annexure 3 of the petition, Elusive.
Petition from affidavit.
Petition, Elusive, this writ petition.
I don't even
Page 13.
Yes, my lord.
So there was maintenance case, Elusive.
My lord, these facts are already there in my petition, my lord. After the marriage, my lord, he
it
ran
is,
into rough waters. He was keeping a concubine. He was keeping a concubine, my lord. Thereafter, he died, my lord. And in the meanwhile,
It is then
there was
the
a
person who is serving in 50th GTC. He was sufferable as in 50th GTC.
these are civil employees in the.
Oh no, but
in
the fact they got married is there. They were not divorced.
No.
Yes. Then you give the details.
So details to whatsoever we have in this. we
No
get first.
details regarding death and securities, whatever.
Death and security, so that I can apply for a succession certificate, my lord.
You can give it. You take instructions.
So death and security already has been taken by the legal
but-
head of the deceased, you will see.
By the first wife?
No. This,
By whom?
This, in my activity, you will given also this, his sister came forward after his death and after the given.
We'll hear another day. Yes, next matter.
29.
Published 2 weeks, yes. At the request of counsel petitioner who says there might be a settlement. Yes. Published.
this matter was partly heard, Your Lordship, on the last occasion. Your Lordship,
Yes.
This matter concerns the cancellation of my appointment, Your Lordship. Your Lordship, an advertisement was floated in the month of June, Your Lordship, 2020, which is at Annexure 1, page 11, Your Lordship, of my...
Annexure 1, page 11.
And thereafter, Your Lordship, I was called for the interview, Your Lordship, which is at... My call letter is at Annexure 8, page 19. And thereafter, I was declared a successful candidate, Your Lordship, and the result of it is in Annexure 10, Your Lordship, of page 21.
1 second, sorry.
I was declared a successful candidate, Your Lordship.
How many candidates appeared?
The successful candidates, Your Lordship, was 56 in total. Now I am at serial number 12, Your Lordship. Your Lordship, however, after having selected, Your Lordship, I was not given an appointment letter, Your Lordship. And on the basis, Your Lordship, I have run from pillar to post to inquire about my appointment. And it was later, Your Lordship, in the fourth quarter of the year 2022, Your Lordship, that I came to know that my appointment has been rejected. So accordingly, Your Lordship, I filed my representation, which is at Annexure 11, page 25, Your Lordship. And thereafter, Your Lordship,
You didn't produce certificate?
Yes, Your Lordship. Your Lordship, the certificate, because I was declared successful candidate on the basis that I will be producing the pass certificate before at the time of appointment. However, Your Lordship, my no appointment letter was issued, and they had just cancelled my appointment.
No, you're supposed to produce your certificate at time interview or at time of appointment.
Your Lordship, as per the advertisement, Your Lordship.
What does it say? Let's see advertisement again.
The advertisement, Your Lordship, didn't say anything.
CM data pass certificate compulsory.
Yes, Your Lordship.
You didn't have it at that time?
No, Your Lordship.
You have it now?
Yes, I have it now. I have it before my appointment, but the appointment was made on...
So they've cancelled the whole selection process?
No, Your Lordship.
Other people have been selected?
Yes, Your Lordship.
They've been appointed from the same process?
From the same process, yes, Your Lordship.
This
The
is class 12 pass, so.
The appointment was made on 13 April 2021, and I got my pass certificate on 8 April 2021, Your Lordship. So the pass certificate was issued prior to the appointment date, Your Lordship. So, Your Lordship...
1 second. Where did he get this from? Did he come to Annexure 14 at point number 2? Where did the respondents get this from then? Point number 2. Accordingly, an order for appeal statement of petitions forwarded by the concerned district was being notified before the interview. Where is that?
Your Lordship, this is...
Is that there, Mr. Harmi, with you?
This is from the inquiry, Your Lordship.
So read the second point, just read it.
Accordingly, an order for an appeal statement for petition forwarded by the concerned district was being notified before the interview, wherein it is stated that all candidates awaiting DLS results are qualified to apply for the vacant post. However, they are to produce the original DLS certificate during the interview, failing which they cannot be deemed DLS qualified. Your Lordship, this has been done, Your Lordship, as per the inquiry, Your Lordship, because they have conducted an inquiry. The inquiry, it's at Annexure 15, Your Lordship, page 30. and the type copy of it is at page 32. At point number 5, Your Lordship, it is stated here that it is reported that the SDSDO office had accepted application from June 2020 onwards and had then accepted.
So now this point number 5 is you say that election board is said to allow this kind of subject question when appointment is issued or at a time of interview. That's the question, right, Mr. Karmi?
Yes.
Is the petitioner qualified?
She was selected, Lordship.
No, but does she possess delayed certificate now?
Now she has got the certificate. But at that time, no, but Lordship, because the appeal committee order is there. That one which he pointed out just now, Lordship, at page 9 of my affidavit.
Your Lordship, that cannot be the case because, Your Lordship, the certificate also was delayed. The result was delayed because of COVID.
Page 9, yes.
Page 9 of my affidavit, Lordship. The relevant portion is page 10. Page 10. The issue, this was issued before the interview. The issues has been examined in reference to the advertisement and the
where is the name?
Dated wherein it is stated that all candidates awaiting DLED results from NIOS are also qualified to apply for the vacant post. Therefore, the application of the above candidates are hereby accepted, but they are to produce the original DLED pass certificate during the interview.
Where's her name here?
Her name is not there.
This concerns only for the UP section, Your Lordship. However, I am for the lower primary. This is concerns the UP section, the upper primary school, Your Lordship.
Yours UP?
Yes, LP. And this concerns the UP, Your Lordship.
She was allowed to appear in the interview subject to production of the certificate at the time of interview. So at the time of interview, she was waiting for the result. She was not able to produce it at the time of the interview. So the government did not approve her appointment.
No, but then his statement is that before the, when did you get it? When was the interview?
The interview was in December 2020, Your Lordship.
December?
December 2020.
The call letter is there. It was conducted in December 2020 on 5 dates, Lordship. 8, 9, 10, 15, and 16.
In one
December
of those, 2020. In one of those dates, Your Lordship.
When did you get a delayed certificate?
The DL certificate I got in April, 8 April 2021, before the appointment, Your Lordship. The appointment was made on 13 April.
You got an appointment letter? I don't understand. Yes. See in point number 7 in page 33 of the petition. That post still exists now?
It has been...
last year it was re-advertised.
Filled up
now. Fresh advertisement was issued last year. She applied and she did not.
But however, Your Lordship, from what I was instructed, it seems the candidate was told that since she has instituted the writ petition, Your Lordship. That's why there has been some.
Well, that means that means they know the answer script who has instituted petition or not. That's not a fair submission, because once you doesn't matter. The only thing is that you see, whatever conditions of appointment or conditions of examination all stems from advertisement.
Yes, Your Lordship.
Okay, advertisement says that your DL certificate is compulsory.
Yes, Your Lordship.
As from, and then, but they given a concession
Yes, Your
that you should produce a time of interview.
Yes, Your Lordship.
That you could not produce a time of interview.
Yes,
And so, according to them, if it was not produced a time interview, then you should have been disqualified straight away.
However, Your Lordship, in the first instance, they should not have appointed me to select me in the merit list, Your Lordship.
Exactly, that is an anomaly.
Yes, Your Lordship. Your Lordship,
but now, now is the added fact is that if the post has been re-advertised and filled up, then there's no relief for you.
Your Lordship, there's one judgment, the recent judgment also, Your Lordship. If rejection is not made at the threshold, Your Lordship, the candidature should be.
No, not the threshold. The thing is that you go by advertisement, then compulsory, you out even before entering. Fine, but they said when they made the concession that okay, fine, that you produce it at the time of.
If Your Lordship may kindly look at this recent judgment, Your Lordship.
Yeah, let's see.
The relevant portion is at paragraph 15, Your Lordship.
Is not reported anywhere else?
I'm not sure, Your Lordship, because it's just got.
Well, live law is not really anyway.
Yes, Your Lordship. The relevant portion is at page number 15, Your Lordship.
Page?
Paragraph 15. Line number 5, Your Lordship. Once a candidate is declared ineligible to participate in the selection process at the threshold, if he still wishes to participate in the process, perceiving that his candidature has been arbitrarily rejected, it is for him to work out his remedy in accordance with law. However, if the candidature is not rejected at the threshold and the candidate is allowed to participate in the selection process and ultimately his name figures in the merit list, though such candidate has no indefeasible right to claim appointment, he does have a limited right of being accorded fair and non-discriminatory treatment. Given the stages of process that the candidate has successfully crossed, he may not have.
No, but your name just came selected. You're not appointed, correct?
I'm selected, Your Lordship. This case also.
No, just selected, not appointed.
Yes, Your Lordship.
Not appointed.
Is there any appointment order in your favor?
No, Your Lordship.
Then?
Not approved.
Because
this case, you see, is already, quite high. You sent for training also.
Yes, Your Lordship.
You won't have a case, and I'm sorry.
In the fresh selection also she appeared, but she was not selected. Last year.
Your Lordship, the stand taken by them, it's the anomalies committed by the selection committee, Your Lordship. That should not be the case, that because a mistake should not be attributed to the right of the
you would have been selected anyway. If you didn't have that delayed certificate at that time, you could not have crossed, you could not have gone for interview also. It's just like that. You didn't have that certificate at the point of time when you went for interview. So there's a clear directive that you should produce a time of interview.
Relaxation.
The relaxation was given. You couldn't produce it there, so what relief can you get now? And your name being selected doesn't constitute any right for appointment. Even if you're meritorious and all other considerations also.
You
take a call, otherwise
selection board should not have
otherwise I don't
declared
think,
as selected also, Lordship. And Your Lordship, this matter I have discussed with the director, and he has expressed his opinion to stick to the norms, to stick to the stand the affidavit. The norms must be followed, and it should not be there should not be any relaxation or departure from the norms.
If you can.
I have discussed it if her appointment can be considered, but the director expressed his opinion to stick it to the stand the affidavit.
This is the matter after 1 week to enable the counsel with the petitioner to come with more authorities. Otherwise, we can dispose it now only. Give another chance since you're putting in effort.
Item 30.
I like to encourage young lawyers to argue. Yes. Yes.
My Lord, in this matter, State was given opportunity to take instruction, my Lord, whether we are willing to accept the settlement agreement, my Lord. So we have received instruction, my Lord, official instruction that they are accepting, my Lord. My Lord, if
What's
this,
the agreement?
this is with regard to...
Or by both of these wives?
Yes, Your Lordship.
My Lord, this is the copy, Lord, you can have it. I don't have a copy. I have, yeah. So, my Lord, they have gone through the settlement agreement which was submitted in the last line of the letter, my Lord. They said it's in order, so they are willing, my Lord, to accept it.
Who has a son?
Both, Your Lordship.
Both the wife
Who's
appears.
getting the pension?
At the moment, it's the respondent number 6.
You are one of 6.
The amount is also decided, my Lord, which is reflected in this letter also.
Yes, sir. Anyway, you will close the matter?
Yes, Your Lordship.
Yes, sir. By order dated 5/9/2024, this court had directed the state respondents to obtain instructions
I don't have a copy.
On a settlement deed. Where's the settlement deed that you showed last time?
Settlement deed. You have submitted to court?
I have submitted.
Well, they have served the
here? Oh, yes, so sorry, yes, it's here.
Dated 15 April 2024.
Settlement deed, settlement agreement, which had been arrived at between the petitioner and the respondent number 6, was stated to be wives of the first and second wife.
The first wife is the is the respondent number 6. Second wife is
Between the writ petitioner who was stated to be second wife and the respondent number 6 who's said to be the first wife of the deceased employee. Today, next paragraph, MSR Kohli on behalf of the state respondents has submitted, has produced a communication dated 20th May 2024 to the effect that the respondent number, who's the concerned authority?
1 3M. 3M 5.
My Lord, I believe it should be 5. Because he was serving in superintendent office, man.
No, well, he draws. Where will the money come from? You're drawing a pension from. You're drawing a pension from where?
It's from July.
But he was an employee of Joy, my Lord. He did.
From no? One. Yes. Has accepted the settlement, the deed of settlement, the proposal of settlement.
You have any pension book?
Given by the parties. So,
Yeah, the pension book will be reflected there from where he's drawing. Pension
the, said communication is taken on board and paid and made part of the record. Accordingly, next part, in terms of the settlement agreement dated 15 April 2024, arrived at between the petitioner and the respondent number 6. This petition stands closed and disposed of.
My lord, this matter also Lordship has directed to verify whether in the service book who is the nominee.
Who's the nominee?
Nominee, my lord, I have already submitted a copy of the same, my lord, to court, my lord, to Lordship on the last occasion. Already submitted. So the name of the son, my lord, by the name of Bipul Sharma is there, my lord. So this was what Lordship has directed the corporation to verify whose name is reflected. My lord, may kindly have page.
What is document submitted last? You submitted this last time.
Yes, my lord. So
From where? Which page?
My lord, page 2. My lord, may come to page 2. Page 2 and 3, my lord. Their Lordship will see in the first column is Amia Devi, my lord. This is the nominee.
Yes, Amia
subsequently.
Devi.
In the fourth column, my
Bipul
lord.
Sharma.
My lord, Bipul Sharma. So this is the son, my lord. It appears to be the son. So here, my lord, the dispute is between the first and the second wife. So they have decided.
Who's Omia Devi?
Omia Devi is the first wife.
You
First
Omia
wife
Devi.
petitioner.
And Bipul is the son of the second wife, my lord.
And the
Son of the second wife, my lord.
the other nominee.
Bipul Sharma, my lord. The name is Bipul Sharma.
You are representing him.
My lord.
Yes. So both of you are nominees.
My lord, they have decided that they will be sharing the pension. That is what they have.
Is that correct?
As per the rule, pension rule, Lordship, the son is also entitled for pension up to 25 years. So
Till the age he attained 25, he may be given, my lord.
now he is 22 years. So
For the next
50% could be.
Is that correct?
Till 25, my lord. Yes. Yes.
Yes. The MSR only on behalf of the Respondent Corporation has obtained instructions and produced the list of the names of the nominees of the deceased employee.
Basanta Sharma, my lord.
See, who's the deceased
Basanta
employee?
Sharma.
See, Prakash.
My lord, the employee name was Basanta Sharma.
Employee Basanta Sharma, who expired on. Don't know. He
My lord, he expired on 2nd March 21.
Who died, who had superannuated on 1/7/2013 and died on
2nd March
2nd
2021.
2021. Stop. In the said nomination form, it is seen that the name of the writ petitioner as well as of the respondent number 6 have been reflected. Correct?
5, my lord.
No, 5 have been reflected. Stop. It has also been submitted that the respondent number 5 presently is aged 22 years, and as such, if any pension is accorded to the said respondent, he would eligible to enjoy the same only for 3 more years till he attains age of 25. Stop. Now, as the pension will allow for sharing a pension between nominees, stop directed that the petitioner and the respondent 5 shall share the pension of the deceased employee on a 50-50% basis till the till the respondent 5 attains age of 25 years, after which the same will be enjoyed solely by the petitioner. In terms of that's out of the above, matter stands disposed of.
Item 32.
Oblige, Your Lordship.
Yeah, please, Your Lordship. Lordship, this is with regard to headmaster matter, Lordship. The impugn order, my lord, was passed by the SDSCO in violation of the principle of natural justice on the basis of an inquiry report, recommendation of an inquiry report, my lord, which is, my lord, on the face of it, he exceeded his power. The respondent authorities, my lord. He has no power to, on the recommendation of such committee, can appoint a new headmaster, my lord. The headmaster can be appointed on the basis of the resolution passed by the managing committee. That is the procedure, my lord. And I was recommended, the managing committee was passed a resolution, and the same was forwarded to the state respondents for approval, and accordingly the managing committee was constituted on 25/11/2022, my lord. And at present there is no managing committee, my lord. The term has expired.
The managing committee?
Yes, my
So
lord.
it's looking after the
Term has expired on 2nd February 2024. And since then, my lord, the salary is not released by the state respondent. My lord has passed an order whereby the impugn order was stayed, my lord. Thereafter, the
salary has been paid.
No, my lord, no salary has been paid. Thereafter, my lord, the state respondent has passed an order, my lord, in their affidavit filed by private respondent.
Who's the private respondent?
My lord, the
who's the lawyer?
I am for my appointment, lordship.
His appointment, yes.
He has challenged my appointment, lordship, as the headmaster of the school.
Yes.
My lord,
today I don't think that matters because it will take time, lordship.
Why?
Because promotion matter, lordship. Here he is a matriculate and I am a BA pass. It might take time. My only submission I like to put, lordship, since there is no managing committee, at least now the state respondent can take over the management of the
When
school.
does the managing committee expire?
My lord, on 2nd February 2024, my lord.
Until the time it's running, how is it running now?
My lord, I am the headmaster, my lord. The respondent authority.
Forget headmaster.
Yes, my
How's
lord.
it running?
There was no
There's no headmaster also.
Yes. Headmaster by virtue of the order of this court, lordship.
Yes, my lord.
But since there is no managing committee.
We will hear it.
Yes, lordship.
Yes, yes, sir. The party is the matter.
My lord, only prayer, my lord, a direction may be given to, because we have filed a representation before the DI.
Direction for what?
My lord, to release the salary. They are suffering, my lord.
Well, here, how long have not been paid?
My lord, almost 6-7 months, my lord.
It's all right. Another 2 weeks won't make a difference.
Yes, my lord. My lord is
If the
correct.
direction is given in the meantime, the management of the school can be taken over by the government. That also
That can be done, my lord.
They can
because they are
provide this.
suffering for
Yes,
this.
lordship.
my
That
lord.
can-
They can file a miss case also.
Well,
You
that
know,
is-
for prayer for.
This is subsequent
It
event,
is
my lord.
reported by the parties that at present there is no managing committee functioning in which school is this?
My lord, Nolbari Janata GA school, my lord.
Nalbari Janata
GA school, my lord.
GA school?
It's government aided, my lord. In short,
Government
it's
aided
GA
school.
school, my lord.
Stop, the parties jointly submit that there's a managing committee which had expired.
2nd
term had
February
expired on
2024. 2nd February 2024.
to 2024. Stop. On the joint prayer with the parties, it is directed that the SDSEO of which of
Dadangiri, my lord. Dadangiri, West Karol.
shall look after the affairs of the school
My lord.
and ensure that the salaries of the teachers who are
My
serving therein
My
are
lord.
paid.
Yes, my lord.
That will suffice.
That is that.
Just a matter of 2 weeks.
My lord.
Highly obliged.
Highly obliged.